There we go. All right, Jeff.
All right, thank you, Stephanie, and welcome everyone. My name's Jeff Aga with Essentials. I'm glad you've all joined us today virtually. It's been a few years since I've been able to get to Michigan Bankers. I used to do some of the on-site training in Lansing as well as Marquette, but it's been a few years. But virtual works wonders as well, and I'm glad you're all here joining us today. Before we get started, Debbie, would you like to say anything before we get going today?
Sure, thanks, Jeff. Well, welcome everybody. Like Jeff, I have had the pleasure of being on site with you in the past there for Michigan Bankers, and I'm happy to do it again today virtually. I will be co-instructing today and tomorrow with Jeff, so we'll be back and forth. And I can't think of anything else at this particular juncture, but glad to see you guys virtually.
Okay, great. Well, hopefully, as Stephanie mentioned, all of you have gotten the handout or the guidebook. We will be using that today. I think you can all see the title screen on my PowerPoint slides, but I'm going to pop up the guidebook here, and so you can see what it's looking like. I've got the PDF here. We're going to be going through a lot of different information today. This is, again, our IRA Essentials course, so you should have something that looks like this. I want to point out how it's laid out. We're going to go through a number of main topics, 4 main topics today: in introduction and establishing IRAs. So we're going to be talking about that. IRA funding, how your customers can make contributions into their individual retirement arrangements. So we're going to talk about that. And then that'll probably cover most of the morning up to noon Eastern. We'll take a short break for lunch, half hour, I think we'll schedule in, and then we'll resume with the afternoon session because we are scheduled until 3 o'clock Eastern. So we've got a lot of information we want to cover. This afternoon, we'll talk about IRA distributions as well as portability, how they can withdraw funds out of their IRAs, and then how they can move their retirement assets between different types of retirement accounts, including their IRAs. But in this guidebook, we'll be going through these different sections, but you'll notice after those 4 sections, we've got a job aid section, a glossary, and an exercise master. So I just want to point out in the back, the job aids, we're going to use that. That's after page 72 in your guidebook. And there's a lot of different things you'll see on slides, other information. And Debbie and I will refer to that periodically as well. And then after that, we have a glossary of terms. This we use a lot of interesting terminology for IRAs, and those are all defined in the back as well. And then at the far back, because we will be doing some exercises, is an exercise master, and that has the answers to those exercises for your benefit. But I always like to say, let's work on the exercise and no peeking. Let's see how well you can do today when we go through those different topics as well. So that's what we're going to be covering today. Again, this is IRA Essentials. It really is going to give you a good solid foundation on IRA knowledge. And we will use those exercises throughout the day to apply that information on the different topics to different situations that you may encounter at your banks. So this should give you a good understanding on how you can conduct some of these basic transactions. So before we get started, we want to also encourage questions. A good way to do that, actually the best, is to unmute your computer or phone and ask that question live. Or another way is you can open up the chat feature, and you'll see on your toolbar, your Zoom toolbar, a little cartoon bubble that says chat. If you click on that, that will give you chat box where you can enter that in. So I want to test that out to see if you all have that capability, and type in your name and the name of your financial institution or bank. So go ahead and type that in. Let's see if you have that chat box working, because Debbie and I will use that not only for questions, but give you an opportunity to answer the questions for the exercises as well. So Kathy, welcome. Veronica, welcome. Debbie's here still. Angela, glad you've joined us all today. So good. It looks like most of you are able to do that. Also, if you do have cameras available on your computer, you don't have to be shy. You can turn that on. We like to see your smiling faces as well. So good. So this is our IRA Essentials class. And again, we're going to be covering those different topics today. So let's get started, and let's take a look, first of all, at an introduction to IRAs, and then we'll look at the process for establishing IRAs. So you'll see our learning objectives on page 1 there of your guidebook. And we're going to be taking a look, and we will identify the different tax advantages for opening an IRA. So we're going to talk about those different tax advantages for opening a traditional IRA as well as a Roth IRA. In other words, why do your customers choose one over the other? And it is because of the different advantages. We'll also look at the process of opening an IRA. So what documents are you going to require to provide them? So we're going to talk about those different things as well. And then we will also look at naming beneficiaries, because oftentimes when they establish their IRA, that's a good time to name their beneficiaries. So that's what we want to cover in today's first session here. So IRA, I've been using that acronym already. What does IRA stand for? You've got your chat open. What does IRA stand for? Chat that in. What do you think IRA stands for? Go ahead and chat your answer. We've got that acronym there on the umbrella, IRA. What does that stand for? Okay, I see Amy and Mary have typed in individual retirement account. What individual retirement arrangement? Kathy? Okay. So yeah, when we talk about IRA, that acronym, and we're going to use that all day long, I stands for individual, R for retirement, and A for arrangement. And if you did say individual retirement account, that is certainly correct as well, because when we look at individual retirement arrangements, we can have individual retirement accounts. That's what you offer at your bank. Or insurance companies offer individual retirement annuities, and they both fall under that umbrella of individual retirement arrangement. So individual, that is a key word. Individual, it must be a person, in other words, a human being, and individual, that means one person. You offer a lot of different accounts at your bank, and oftentimes you may have more than one person's name on that account. You probably refer to those as joint accounts. Typically, a joint account might be held under the name of a husband and wife or a married couple. With IRAs, though, individual is a key word. That means only one person's name can be on the IRA. So the husband would have to have his own IRA, and the wife would have to have her own IRA. We don't have any joint IRAs. Retirement, simply the state of being retired from one's job or occupation. And we all hope to get there someday. At least I certainly do. So when we retire, typically we're no longer working. And the whole purpose of the individual retirement arrangement is to give the individual the opportunity to set monies aside to provide income when they are no longer working. In other words, provide them some money that they can live off of during their retirement years. Arrangement, an agreement or settlement. The arrangement is really the investments that are held in the individual retirement account or the annuities. I also like to think of the arrangement as maybe the governing documents. We're going to talk about the documents that you are required to provide to the IRA owner when they establish their IRA. So when we look at the individual retirement arrangement piece, think of it as the document that allows them to save on a tax deferred basis to provide themselves some retirement income. So when we talk about individual retirement arrangements, they could be held in a trust account or maybe a custodial account at your bank, or with an insurance company under an annuity contract. And really the whole idea is to provide a means to hold assets to be able to provide income during their retirement years. So again, individual is a key word. Only one person's name will be on that IRA. In other words, it cannot be owned by an entity such as a trust. We could name an entity as the beneficiary. We'll talk a little bit about beneficiaries today as well. But when we look at it, it has to be set up for just one person. So when we look at individual retirement arrangements, it's really a tax advantage savings vehicle, if you will, designed to provide retirement income during their retirement years. Other sources that they might rely on would be Social Security income. Maybe they're in an employer-sponsored plan, such as a 401k plan or profit sharing plan, or maybe a money purchase plan or pension plan. Those employer plans can also provide the individual with income during their retirement years. And then their personal savings. And that's where IRAs fall under, is their personal savings, because it gives the individual the means to set monies aside. So with those three sources of income, they should be able to have a fairly comfortable retirement by being able to draw off of those. And if not, they might have to continue working and rely on some wages, for instance. So when we look at IRAs, we can have different investments held under that umbrella of the IRA. So think of the individual retirement arrangement as an umbrella, and under that umbrella, we hold the investments that are really designed to provide that income. We could have savings accounts, we could have certificates of deposits. It might be held with maybe a brokerage account where they invest in stocks, bonds, or mutual funds. So we could have a multitude of investments under that umbrella of the IRA. So what investments do you offer for your customers when they establish an IRA? Chat that in the chat feature. What are your primary investments that are offered at your bank? Go ahead and chat that in. What investments do you offer at your banks for your IRAs, if you know? Okay, Amy says certificates of deposits. Veronica, CDs, certificates. Yeah, so certificates of deposits are very common at depositories such as banks as the investment to provide that income during their retirement year. Now, if you take a look, we have savings accounts. So maybe also you offer a savings account as an investment and a certificate. So they could have both underneath that individual retirement arrangement. So if you think about it, each certificate does not create a new IRA. And we're going to talk about the arrangement piece, the plan agreement, which is our governing contract, which creates the IRA. And once that's created, then underneath the umbrella is where we would hold our investments. So when we take a look at that, we could have individual retirement accounts, or we could have individual retirement annuities. So you offer individual retirement accounts. Insurance companies offer individual retirement annuities. Generally, really, they're going to use the same, follow the same rules, but they use different terms. For individual retirement annuities held at insurance companies, the insurance company offering that annuity is sometimes referred to as the issuer. They refer to the IRA owner as the annuity contract owner or annuitant. The governing instrument for that annuity is referred to as the contract. And then when they fund it, they pay premiums into that contract to save for their investments. And then the value is called the cash surrender value. And then when they take payouts from that annuity, they take annuity payments. Well, we're not going to use those terms that you find there on page 2 for individual retirement annuities. But I like to point that out just in case your customer might have one that maybe they're going to be bringing to your bank, and you might hear some of those terms. We're going to refer to the terms today for individual retirement accounts because that's what you offer at your bank. So your bank will act either as a trustee or custodian of that account, the individual retirement account. The IRA owner is sometimes referred to as the grantor or depositor. Will more than likely be using the term individual or IRA owner today to refer to the grantor or depositor. For the arrangement, the governing instrument is referred to as a trust instrument or plan agreement. We're going to look at those documents and look at the plan agreement today as well. So we're going to take a look at that, and we will be talking about those things today when we look at the governing documents as well. When they fund it, and Debbie's going to cover funding a little later this morning, we say they make contributions. So when they deposit money into the individual retirement account, we say they make a contribution. She's going to talk about regular contributions, catch-up contributions. Later on this afternoon, when we talk about portability, we will see that we could also have rollover contributions coming in. So there's many different ways to fund the individual retirement accounts. The value of the account is referred to as the account value. That's the value of the accumulated assets that are held in the IRA. And then when they talk about and take money out of that, we say they take distributions. So the withdrawals out of the IRA is referred to as a distribution. So those will be the terms that we're going to be using today, but we could have an individual retirement arrangement that's held in an individual retirement account, or we could have one held at an insurance company held in an individual retirement annuity. So we can have different investments. We can't invest in life insurance or collectibles, though. That is prohibited under the law. But generally, they're going to be subject to the same rules. Okay, so those are some of the terms we'll be using. Any questions so far? If you have a question, the easiest way is to unmute your computer or phone and ask that question, or you can simply chat that in the chat feature and we'll take a look and get those questions answered. Okay, now on page 3 and 4, you'll see that a little legislative history of IRAs. So individual retirement arrangements, as I mentioned, are tax advantage accounts that an individual can set up to accumulate their funds to provide them some retirement income. And depending on the type of IRA, the contributions that they use to fund those can be made on a pre-tax or maybe an after-tax basis. And then the investment earnings are going to be tax deferred. And in some cases, under the Roth IRA, they may be withdrawn tax-free as well. So we have a number of different pieces of legislation that have affected these IRAs. And you'll see that listed on job aids 3 and 4. So if I pull this up and we'll take a look at what you can see a little legislation history. All of this also can be found in your job aids section in the back, and it outlines what all of these different laws are referring to. But let's take a look at some of the key ones. Back in 1974, Congress passed a piece of legislation referred to as the Employee Retirement Income Security Act of 1974. That's sometimes referred to as ERISA. And what ERISA did was it originally gave those that were working for an employer that did not have pension coverage the ability to set monies aside, 15% of their income, not to exceed $1,500, to be able to save for their retirement, to be able to provide them retirement income. And that permitted them to be able to start setting monies aside to save if they weren't covered under an employer plan at work. Well, in 1981, they made that available to all workers and spouses eligible for IRAs. So it gave them the ability to start putting monies aside even if they were covered by an employer plan. The big advantage of that was when they funded that IRA, they were able to take a deduction from their taxes on the contributions that they made. And all of the earnings grew tax deferred. So it gave them an incentive by offering that tax advantage to them. So we saw a lot of changes that happened throughout the year. In 1986, Congress passed a law referred to as the Tax Reform Act, and that's when they rewrote the tax code, and they limited the eligibility for tax deductible contribution to individuals whose employers do not sponsor plans, and also based on what their earnings were for that. So they were able to make contributions that were deductible if they weren't covered by a plan, but if they were covered by an employer plan, depending on what their income was, they were no longer able to take a deduction. So deductibility became an issue in 1986. Now, because of that, we found out that a lot of people quit saving in their IRAs for their retirement because they weren't given the deduction because maybe they were in a 401k plan at work. Well, in 1997, there was a gentleman, a senator from Delaware, Senator William Roth, and he said, well, because the individuals aren't saving like we intended, let's create a new IRA where they don't get to take the deduction, but all the earnings that grow in that IRA can be withdrawn penalty and tax-free if they're qualified deductions. So in 1997, they created the Roth IRA, which gave them a new type of IRA that when they funded it, they did not get to take the deduction. In 2001, Congress passed some sweeping legislation under the Economic Growth and Tax Relief Reconciliation Act that increased our contribution limits, which they also indexed these limits for inflation, and they get adjusted for cost of living. They also created a new contribution for those getting closer to retirement referred to as a catch-up contribution. And it also gave a tax credit for an incentive for lower income individuals to also save for their retirement. So we saw a lot of changes throughout the years under these different pieces of legislation. In 2001, under EGTRA, not only creating the higher contribution limits, they made it easier to move around. And also for 401k plans, they also gave them a Roth option that if the employer chose, could offer that. Well, an interesting thing about this piece of legislation, the very last page had a sunset provision that said that at the end of 2010, unless a future Congress acts, all of these great provisions that Congress had passed in 2001 were going to revert back to the old rule. Well, in 2006, Congress made those provisions permanent under the Pension Protection Act. Another thing that came about under the Pension Protection Act was they made it easier for non-spouse beneficiaries of employer plans to be able to roll to inherited IRAs to use the distribution rules. Most recently, under FCAA, which was the Further Consolidated Appropriations Act of 2019, that was made up of a number of bills. Under that, FCAA was what bill called the Setting Every Community Up for Retirement Enhancement Act, sometimes referred to as SECURE. And that repealed the age for traditional IRA contributions. It also increased RMDs to age 72 instead of age 70 and a half. And it required more rapid payouts to non-spouse beneficiaries as well, with some exceptions. So we saw a lot of changes that came up under the SECURE Act, and then also for the early distribution penalty tax, created a new exception for qualifying birth and adoption. So we saw a lot of changes under SECURE. In 2020, under the Coronavirus Aid, Relief, and Economic Security Act, of sometimes referred to as the CARES Act, they waived required minimum distributions for IRA owners and beneficiaries for that year. So we saw some changes under that. So these are some of the major changes. Now, most recently, just the end of last month, there's another piece of legislation, SECURE 2.0, which also increased the RMD age again now to age 73. So we'll be talking about that more in distributions. So as you can see, we have a lot of information, and Congress has created these incentives for individuals really to save for retirement. Now, back in your job aid section, there's a complete listing of all of those laws that we show on page 4 there in more detail. So if you're interested, where did this come from? When did withholding start? All of that's explained in the back. I just wanted to give you a little high level of what's taken place here over the years and how Congress really creates the rules regarding IRAs. Why do I cover that, and why does Debbie talk about this a little bit? Well, we're going to talk about all these different things with our different topics that we cover today. We'll talk about deductibility for contributions to traditional IRAs. We're going to talk about how someone with a Roth IRA is able to take their earnings out tax-free through a qualified distribution. So we're going to cover a lot of these things that were changed due to legislation throughout the years. Okay. Now, why does your bank want to offer individual retirement arrangements? Well, there's a few key benefits for your financial organization. First of all, if you offer IRAs, it provides stable long-term assets for your bank. Well, because if you think about it, an IRA is really a savings vehicle to provide retirement income later on once they reach their retirement years. So they're really setting monies aside for the long term. And that does provide a source of stable long-term assets for your bank then. It also builds long-term relationships with your customers. So if you have the IRA business, they're probably going to come in and for other business as well. They'll have their checking account. There may be some savings accounts, other CDs and savings vehicles as well. And maybe they're coming in to take loans out to maybe purchase their home or buy a car as well. So if you look at it, it builds a good relationship with your customers. And then finally, it's going to keep you competitive, because if you don't offer IRAs at your bank, guess what? The bank across the street is going to offer them, and they may go there to be able to set monies aside for their retirement. Okay, let's discuss tax advantages and why someone might want to open a traditional IRA or a Roth IRA. So when we talk about IRAs, we have traditional IRAs and Roth IRAs. And based on the type of IRA, they offer different tax incentives to encourage individuals to save for their retirement. And when we look at this, there are some differences. We'll talk about those differences, such as deductibility for traditional IRA, who's eligible to contribute to a traditional or a Roth. Debbie will talk about that with funding as well. And then we'll take a look at those, why they might want to do that. But let's first talk about the tax treatment for traditional IRAs and why someone might want to contribute to a traditional IRA. Well, first of all of the earnings in that traditional IRA that are generated under your certificates of deposits are tax deferred. So what does that mean? Well, that means you are not going to report the IRA earnings to the IRS or your customer on a 1099 INT. That form 1099 INT is interest income. Typically, if they have a regular certificate or savings account at your bank, you have to send those out each year. And the account owner then has to take that form 1099 INT and report that as income on their individual income tax return, the form 1040. Well, because they are tax deferred in a traditional IRA, you're not going to generate the 1099 INT on those earnings. Those earnings are tax deferred. Deferred being the key word. What does that mean? Well, we get to put off the taxation of those earnings until the year they take a distribution out of their traditional IRA. So all of their earnings will always be tax deferred. Another incentive created under EGDRA is the Savers Credit. So if an individual qualifies for the Savers Credit, which by the way is a non-refundable tax credit on those contributions that they make, the individual is able to reduce their taxation when they file their income tax return. So to determine if the IRA owner qualifies for a tax credit, typically they should be discussing it with their tax advisor, but oftentimes they may not have a tax advisor because it's really the incentive for lower income individuals. However, if they report on their taxes that they're making these contributions, they could qualify for that tax credit, and they'd be completing a form 8880, which is the credit for qualified retirement savings contributions. So if they do their own taxes, maybe they're using TurboTax or another online program, and they note in that program when the program asks them, did you put anything in your retirement account? Well, generally that form would get generated for them, and they would be able to receive that tax credit. So the earnings are always tax deferred. Another possibility is they may be able to take a tax credit. And then also, they may be able to take a tax deduction. That might be possible. So Congress created income tax deductions for IRA contributions, really to encourage the individual to put monies aside. Well, as I mentioned, in 1986, they made some changes to those rules, and these traditional IRA may or may not deductible, depending on whether or not they're covered under an employer-sponsored plan. So they may not be afforded the tax deduction on the contribution if they're covered maybe under a 401k plan at work, and if their income is above a certain threshold. So they should really talk to their own tax advisor and whether or not they can take the deduction. They can still fund it even if it's non-deductible. So they're able to make the contribution into the traditional IRA still. They just don't get to take the tax deduction. Well, if they do that, then they need to track those monies. So later when they withdraw the monies, and we'll talk about this in distributions this afternoon, that portion that they don't get to take that tax deduction on, the non-deductible contribution, will not be included in income when they later take the withdrawal. So they should really talk to their tax advisor. The IRA disclosure statement also gives them information on if they can take a deduction on that, and also publication 590A, which is a publication for individual retirement arrangement contributions, does have information regarding that. Okay, so we're talking about those tax advantages. Can anyone tell me what the difference between a tax credit and tax deduction is? We don't want to have you give any tax advice to your customers. Leave that to their tax advisor and tax professionals. But since we're talking about these advantages, what's the difference between the tax credit and tax deduction? Does anyone know? If you happen to know, go ahead and unmute that phone or type that into the chat. What's the difference? What is the difference between a tax deduction and a tax credit? Okay, not seeing a lot of responses. Well, since we're talking about these benefits and advantages, let me explain the difference, just so you have a good understanding of these concepts. A tax deduction, if they're eligible to take that deduction, is going to reduce the income that they calculate their income tax on. So for example, someone earns $70,000 of income and they make a $5,000 contribution into their IRA, which is deductible. Well, instead of calculating their income tax on the $70,000, they get to take a deduction of the $5,000 deductible contribution. So it's $70,000 minus the $5,000. Now they calculate their income tax on $65,000. So the deduction reduces the income that they calculate the tax on. Now, that's the deduction. The tax credit's even better, because if they're eligible for a tax credit, and the saver's credit is a non-refundable tax credit, if they put the contribution in and they can look at that tax credit and they're eligible for the tax credit, they get to actually reduce the tax owed. So if they owed $1,000 based on their income, and they contributed to a traditional IRA, and when they determine what their tax credit is, let's say their credit is $200, then that individual actually gets to send in a check only for $800. So the $1,000 tax owed minus the $200 credit is $800. So a tax credit's even better. It reduces the tax owed. So a deduction reduces the income we calculate the tax on, and a credit calculates or reduces the tax that is owed. Okay, any questions on those concepts? Okay, now for Roth IRAs, just like the traditional IRAs, those earnings are going to grow tax deferred always. So if they're holding a certificate of deposit under the umbrella of a Roth IRA, there will not be a Form 1099 INT interest income form sent out each year on those earnings. Those earnings grow tax deferred. Just like contributing to a traditional IRA, they might qualify for that tax credit. So the contributions are not deductible like they may possibly be with a traditional IRA, but they could, if they fund a Roth IRA, possibly be able to take a tax credit as well. So when we look at that, they might be able to lower the tax owed. Now, the big advantage of the Roth IRA is that the earnings that are growing tax deferred, if they have a qualified distribution, can be withdrawn tax free. So we'll talk about qualified distributions this afternoon, but generally in order to have a qualified distribution from a Roth IRA, they have to have met a 5-year period and have a qualified reason. And we'll talk about those 4 reasons: age 59 and a half, death, disability, and if they qualify as a first-time home buyer. So if they have a qualified distribution, then the earnings also get to be withdrawn tax-free. So that's the big advantage of why individuals might save in a Roth IRA. Okay, any questions? Okay, now regarding that tax credit, I just want to bop back to the job aid section here, to job aid 6. This shows the income that they could have, and we're talking about the 2022 tax year now, since that's what we're getting into. If their income falls within these ranges, based on funding it, they can consider up to $2,000 of retirement savings that the taxpayer puts in themselves, either in a traditional IRA or Roth IRA, and it's based on their tax filing status. So we see these are going up in 2023. So let's just take a look at a quick example of this. Tracy's 24-year-old. She has no dependents, has adjusted gross income of $31,000 in 2022. And she's not a dependent or full-time student, and she files as single. So all other cases back there in your job aids section, we're going to look at that. Her income of $31,000 falls between that. So if she puts $6,000 in her Roth IRA for 2022, she can only consider $2,000 of that contribution for her non-refundable credit. So 2,000 times 10% is going to be a $200 credit that Tracy could have if she made that contribution. So that's how the credit works. And since we have that in the job aids, I just wanted to point that out. Okay, any questions on the tax advantages? Okay, on page 7 of your guidebook, we've got an exercise. I'm going to give you just a minute to read through these questions, and then we're going to go through these together. So take just a moment to read through those questions, and then we'll go through those together. We'll give you an opportunity to chat your answers in. So go ahead and just take a minute and read through those, and then we'll answer those together. Okay. Our first question, Benjamin has a traditional IRA and a Roth IRA. Will the interest earned on his IRAs be included on a Form 1099 INT? Chat your answer in the chat feature there. What'd you come up with? Yes, no, or maybe? Chat your answers in. Will the interest earned in his IRAs be included on a 1099 INT? Very good. No, they will not, because they are always tax deferred. The earnings in both traditional and Roths are always tax deferred. Okay, our next question. Jacob has a traditional IRA and a Roth IRA. Which IRA gives him the opportunity to possibly take advantage of the savers credit? The traditional IRA, Roth IRA, or neither? What do you think? Kathy, Veronica, very good. Yeah, he could with a traditional or a Roth. So he would be able to potentially get the savers credit by funding either one of those. All right, question 3. Vanessa has a traditional IRA and a Roth IRA. Which IRA gives her the opportunity to possibly withdraw the earnings tax-free? Which one is that a advantage for? Yes, very good. The Roth IRA. And finally, can Evelyn take a tax deduction on a regular contribution made to her traditional IRA? Yes, no, or maybe? Yeah, maybe. We don't know enough about Evelyn to whether or not she gets that deduction, because we'd have to know what her income is, or modified adjusted gross income, and whether or not she's an active participant in an employer plan or married to an active participant. So that is something she should be discussing with her tax advisor. Okay, any questions on the tax advantages of why someone might choose a traditional over a Roth IRA? Any questions? Okay, let's take a look at the process of establishing an IRA now. So when we take a look at establishing an IRA, the first step is in establishing the IRA, maybe your customer comes in, is they may have questions to ask you. So you want to be able to provide them information, but you don't want to give them any tax advice. In other words, don't apply that to their own personal situation. They need to identify the type of IRA they want. Are they going to want a traditional IRA, or are they going to want a Roth IRA? So they need to tell you which type of IRA. You can explain the rules for each IRA, but don't apply those rules to their own personal situation. And then you can also describe what investment options they have at your bank. Do you offer a 1-year CD, a 3-year CD, 5-year CD, a savings account? What type of investments do you offer? So the first step when they establish that is really to understand what you're offering for your customers when they come in and want to open a traditional or a Roth IRA. Okay. Next, then we need to provide them with 3 documents that the IRS requires. So the 3 required documents are the plan agreement, a disclosure statement, and financial disclosure. So you're required to provide these 3 documents. If you take a look at it, we all are familiar with Adobe Acrobat, and usually they're generating what's called a PDF. So we want to just kind of remember that through that acronym PDF, plan agreement P, disclosure statement D, F for the financial disclosure. So our 3 required documents that you have to provide the IRA owner at the time they open that is an up-to-date plan agreement, an up-to-date disclosure statement, and a financial disclosure. Now, some of your banks may also have them complete an IRA application. So the application is used also in addition to these 3 documents to get that opened up. You may also have to provide them with regulatory documents such as a truth in savings disclosure, the customer identification program disclosure or CIP requirements. And once each party has signed and received these required documents, we have that IRA established. And once it's established, then the IRA is ready to be funded. So these are the documents, and we're going to take a look at the PDF a little closer. We'll talk about the application because many of you might be using that. In fact, Essentials offers our PDF and an application in one neat little package. We call that the simplifier. Do any of your banks use the Essentials simplifier for your opening documents? Chat that in if you use the Essentials simplifier. Amy says no. Are you using one from another one called the organizer? I bet maybe that's the one you may be using. That's offered by another company. The organizer is offered by Wolters Kluwer, so some of you might be using that. And they have all of the, primarily a lot of the same information that are found in these documents. Okay, so let's talk about, first of all, the application. So when we take a look at the application is really designed to gather information about the IRA owner that's establishing it. Recall that I for it means an individual. That means a person has to be completing this application. It can't be for an entity. So what information do you think you need to gather about the IRA owner? Chat that in. What information do you need to get about the IRA owner on the application? What information do we gather on the application? Well, the information, yep, Amy, very good. Name, tax ID, address, date of birth. Kathy, yes. Veronica, yeah. We want to gather all the information about the IRA owner. So when we're gathering that, we want to get their legal name. And if you take a look at this, this is a copy of the Essentials simplifier. As I mentioned, you might, many of you might be using the Wolters Kluwer organizer, their applications gathering that same information. So when we're doing that, we want to get the IRA owner's legal name. Okay, that's why you'll see first MI for middle initial, last name, their address, their social security number or taxpayer ID number is what we need. Date of birth, how can we reach them, phone number, email address. You can put your contribution there. And when we take a look at that, we need to gather that. Now, why do we need that information? Well, we're going to talk about tax reporting when they fund this, and because the tax reporting that you're required to send in when they either make a contribution or maybe take a withdrawal requires all of this information about the IRA owner. So for tax purposes, if you think about it, because they're tax deferred savings vehicle, and because of that tax advantages, they have to do certain reporting on their own income taxes, either when they fund it or in some cases when they're taking withdrawals or distributions out of that. And the tax reports, the form 5498 is the IRA contribution information form, which is reported to the IRS when it's funded. And then when they take a withdrawal, an IRS form 1099-R reports those distributions to the IRS and the IRA owner. And because they have to report that under their name, address, social security number, we need to gather all of this information for tax reporting purposes. So if you take a look at this, part one is where we gather information about the IRA owner. Part two would be where your bank's information as trustee or custodian would be listed. Part three, how are they funding it? Are they making a regular contribution and how much? What's the date? Are they funding it with a rollover or a transfer in? So we can capture that information. We can also gather information regarding what's the investment, is it a certificate of deposit? How much is it? What's the term or maturity date and interest rate? We can gather all of that information under that section. And again, your organizer application, I believe, captures a lot of this information as well. Now, the second page, part 5, is where we can gather information about their beneficiaries. So when they establish an IRA, they may want to designate beneficiaries. So oftentimes this beneficiary designation is included with the application. It allows the IRA owner to name their beneficiary. Their primary beneficiaries will be the beneficiaries that receive the assets in the event of the IRA owner's death. Contingent beneficiaries will receive the assets after the IRA owner's death if all the primary beneficiaries die before the IRA owner. So when we look at that, we can name the beneficiaries under this section as well. So that beneficiary section, we can have primaries and contingents. Now, they should list the name if they have multiple beneficiaries and what portion they will receive. So are they going to get 50%, 25%, 100%? What is their percentage? So if we have multiple beneficiaries, all of the percentages should add up to 100% for each level. And again, the contingent beneficiaries are only going to receive the assets in the event of the death of the IRA owner. So, for example, we have on our beneficiaries, we could name primary beneficiaries. On my IRAs, I've got my wife, Sarah, as my primary beneficiaries. But I also have named 3 of my children as contingent beneficiaries. Well, in order for a beneficiary to receive the assets, they have to survive the IRA owner. In my case, they have to still be alive when I pass away for them to be entitled to that. So because I've named John, Molly, and Emily as beneficiaries, as contingents, and Sarah as my primary, if Sarah were to die before me, that's when my contingents then would receive the assets. Now, take a note on this. If no beneficiaries are named, it says that my estate will be the beneficiary. So if we go to the back to, and I think it's on 9 here. Yeah, job aids 9. We've got the whole simplifier here where we can complete the application. And on that, in fact, let me blow this up a little more so you can see it. If no beneficiaries are named, my estate will be the beneficiary. So we've got that where we can name that as a beneficiary. So if no one's named, it would be the estate that would be the named beneficiary. So again, we want to make sure we get our percentages to equal 100%. Any questions naming the beneficiaries? Any questions? Okay. On page 13 of your guidebook, we have an exercise here for beneficiary designations. So if I pop that back to 13, I want to give you the opportunity to take a look at these, read through that. We've got Mitch, who's the IRA owner. He's named Joelle and Derek as primary. You can see their percentages there. Abby and Jackson are contingents. Answer those 3 questions. I'll give you just a moment to read through those, determine who will be the beneficiary, and then we'll work through these together. So take just a minute to read through those, mark up your guidebook or write those answers down, and then we'll give you a chance to chat in the answers. Sorry about that. I'm talking away and I was muted. Okay, so we've got Mitch here. He's named Joelle and Derek as primaries. Joelle's 75%, Derek's 25%. Abby and Jackson are contingents, and Abby would receive 60% of the IRA and Jackson 40% if they survive. So if Mitch dies before any of his primary or contingent beneficiaries, what percentage of the IRA will each beneficiary receive? How about Joelle? How much would she receive? Would she receive anything? Chat that in. How about Joelle? What would Joelle get? Yeah, Joelle's going to get 75%. How about Derek? What would Derek get? Anything? Yeah, the primary beneficiaries are going to receive it if all of them survive. The contingents, Abby and Jackson, would not be entitled to anything. Now, if Joelle dies before Mitch, but Derek, Abby, and Jackson survive Mitch, what percentage of the IRA will each beneficiary receive? How about Joelle's estate? How much would Joelle's estate get? Yeah, 0. How about Derek? He's the primary. How much will he get? Veronica, Kathy, yes, they say 100%. So with our primary beneficiaries, if one dies, it is going to go to the surviving. So Joelle dies before, all of her share will go to Derek. So Abby and Jackson would not get anything. Now, if both Joelle and Derek die before Mitch, but Abby and Jackson survive, what percentage will Joelle's estate get? What would Joelle's estate get? 0. How about Derek's estate? Anything? Right, 0. So that's when the contingents now are entitled to it. So what's Abby's share? What would Abby as a contingent get? Yeah, she would get 60%, and Jackson, he would get his 40%. Very good. I think all of you have a good concept on what the beneficiary designation and amounts they would get. Any questions on naming beneficiaries? Any questions on naming beneficiaries? Okay. Now, when we name beneficiaries, some states require that we get permission to name others as beneficiaries. So when we take a look at that, if they were living in any of these states that are shaded in, these are referred to as community or marital property states. And some states that have these community and marital property laws, in order to name someone other than their spouse as the sole primary beneficiary, has to get the spouse's permission. Here in Michigan, they're not shaded in, so we do not need to get the permission. Where I live in Minnesota, I can name anyone or any entity as my beneficiary, and I would not need Sarah's permission. Although if I were to do that, I'd probably better get it. Where Debbie lives here in Wisconsin, if Debbie were to name someone other than her husband as primary beneficiary, if she wanted to include her boys, for instance, as primaries, he would have to give permission and consent. So on the application, you'll see a spot where they can do that. This isn't required in Michigan to get the spousal consent. If someone completes that, that certainly wouldn't hurt anything. They could do that. Now, that's part 6. It's not required in Michigan, but if they sign it, that's fine. Now, the final section is the signature section, okay? So many IRA applications is going to contain this, and both parties, the IRA owner and the financial organization, have to sign this. So signature of the IRA owner, signature of the custodian, and that will do that. Now, the signature section also can get confirmation that they've received those 3 required documents. We're going to talk about those next: the PDF, the plan agreement, disclosure statement, financial disclosure. And if you look at that, it says, I have received a copy of the IRA application, the 5305A account agreement, the financial disclosure, and disclosure statement. So when we look at that, it can capture all of that information. So you have confirmation that they've been given that amount as well. So if we take a look at back in our job aid section on 9, we've got our application, and then down on our signature section, we are showing that they've got those 3 required documents when they sign it right on here, that they've got the application, the plan agreement, and disclosure statement. So we've got all of that information. The IRA owner should sign it, the custodian should sign it, and we've got our IRA established. You can also see that on page 11 in your guidebook as well. So let's talk about those 3 required documents that we have to provide them. First of all, the plan agreement, that's our contract. We can use IRS model forms. Most of you, if you're using an organizer or the Essentials simplifier, are using the model forms. We also have to provide them with a disclosure statement, which is a non-technical explanation of the rules. That typically will be in your organizer or simplifier. That will tell them all of that. So it's provided by a forms provider. The IRS says you could use IRS publication 590A and IRS publication 590B. IRS publication 590A is contributions to individual retirement arrangements. 590B is distributions from individual retirement arrangements. But if you use that, you've got 2 PDFs that are going to be around 120 pages that you're providing to the IRA owner. So most of you are probably using your simplifier or organizer. And then the third requirement, the F, is going to be to provide them with a financial disclosure, which is our growth projection. So let's talk about these 3 documents. First of all, the plan agreement. So when opening a traditional IRA or a Roth IRA, the financial organization, you have to provide them with an up-to-date plan agreement. What do we mean by that? Well, it means you're providing them the most recent one. And if you use the model documents, the most recent one that the IRS has provided. And that plan agreement really serves as a contract between your bank and the IRA owner that's creating the IRA. So both parties have to enter into that agreement. So that's where we capture the signature of not only just the IRA owner, but someone from the bank acting as the trustee or custodian. And then you have to provide that up-to-date copy to the IRA owner. You should retain a copy of that plan agreement in their file, or at least a signed statement of receipt of the IRA owner's file. So if you take a look at that signature section that we just looked at, we show that we have confirmation that they received that plan agreement. From time to time, these do get amended when we have law changes. So currently the IRS is updating their model documents. We thought they were going to be amended by the end of last year, but now we've got an extension because the IRS has not provided that. So when we take a look at that plan agreement, that can give us that information, and from time to time it will be amended. Now, also, we are gathering information about that, and it tells the IRA owner certain information. It can tell them if they don't designate a beneficiary, it may identify the default beneficiary. So if we take a look at that, what is the default beneficiary in your plan agreement? Well, that might be something if you're not using the Essentials simplifier. Take a look at your organizer in your plan agreement. Section 8 will have additional information in that, and if we take a look at the simplifier, 8.07, I believe, is where it is where we have beneficiary information. I pointed it out in the application, but it also says here in the plan agreement, if you do not designate a beneficiary, or if all of your primary and contingent beneficiaries predecease you, your estate will be the primary beneficiary. So take a look at that, read that over. It's been a while since I looked at the organizer, but what I recall is the estate in that document also would be the default beneficiary. So when we look at the plan agreement, it's made up of a number of different articles, and that tells us what is outlined and agreed upon with the IRA owner and your bank. And the IRS says you have to have certain information in that. So when we take a look at our plan agreement, I just showed you part of section 8, but on your job aid section 9 is where we're going to, or pardon me, 11 is where the thing is. Now it says form 5305 under 408A of the code. At the very beginning, this is telling us that this is a model document. So when we take a look at this section here, that's going to be our document. So it's a model document, and it's a custodial account. Now note that we've got a number of different articles. There's 8 articles for a traditional IRA, and then we have 9 articles for a Roth IRA. So if we take a look at this on page 18, we kind of outline what is in there. You might want to take a look at these sometimes. Now notice that we've got 8 articles for our traditional, 9 for our Roths, and they all kind of have a lot of the same information. The reason we have 9 articles for Roth is Article 2 has been inserted into the Roth plan agreement, and that has the modified adjusted gross income restrictions for making annual contributions, which is gradually reduced for higher income limits, and eventually if they make too much money, and Debbie's going to talk about that when she talks about funding, is that they're not eligible to contribute to the Roth. So Article 1, basically it says for a given year, financial organizations may not accept more than the acceptable individual limit as an annual contribution. And unless it's a rollover contribution, that contribution must be made in cash. So Article 1 for both traditional and Roth IRAs basically are stating, unless it's a rollover, and this is kind of a technical explanation. So it says, except in the case of a rollover from section 402C, 403A4, 403B8, 408D3, 457E16, an employer contribution as a SEP, it says all of that. And then it says our contribution limit. So as we can see here, it's in fairly technical language, but it's saying that these are the limits that they could contribute. So Article 1 sets our contribution limits. Article 2 for Roth IRAs, as I mentioned, is the modified adjusted gross income restrictions for who's eligible to contribute to a Roth. Article 2 and 3 are our non-forfeitability clause. It says the IRA owner's interest in the IRA is non-forfeitable. Well, what does that mean? All that really is simply saying is all the money in that IRA is the IRA owner's money. So we've got our non-forfeitability clause. Article 3 for traditional and 4 for Roths are our IRA investment restrictions, where it states that we can't invest in collectibles or life insurance. So that lists those restrictions. Article 4 and for Roth IRAs, Article 5 are our distribution rules. This is a little longer, and based on that, it outlines what are the rules when they take withdrawals out of their IRAs, and it also lists what are the rules for beneficiaries. Now, Article 5 and Article 6 for Roth IRAs. That's reporting responsibilities. So basically, when we took a look at Article 5, for instance, in the traditional, the IRA owner agrees to provide information to your bank so you can submit required reports to the IRS. So that's the reason why we get their legal name, their address, their date of birth, and social security number for these reporting requirements. Article 6 and 7 are controlling articles, and that just states that Articles 1 through 3 for traditional and 1 through 4 for Roths cannot be modified by other articles. And then Article 7 is our amendments, which means from time to time that the plan agreement may be amended for law changes. Now, Article 8 and Article 9 is where we find additional provisions. I would suggest that you take a look at your Article 8 for traditional and Article 9 to see what you have listed in there when you provide that to your IRA owner. I showed you the default beneficiary, but it has a lot of other information as well. So our plan agreement, the P in PDF, is our contract, and that is what we're going to find in the contract. Okay, now the D, disclosure statement in our PDF acronym, is a non-technical explanation of the rules. So when we provide them with their plan agreement, we also, because it's written in kind of technical language, we have to also tell them what that really is saying in that plan agreement. So one of the requirements the IRS says is that we have to provide them with an up-to-date disclosure statement and explain these IRA rules in a manner that's easy to understand. So you have to provide that again at the time that the IRA opens their IRA or establishes it. You should retain a copy of that in the file or a signed statement of receipt in their file. We looked at that signature section, which states that they have the plan agreement and disclosure statement. So you've got that if you're retaining that. And also when they receive that, that's going to also begin a revocation period where they can change their mind if they open that. So if we take a look at the disclosure statement, and instead of looking at that and looking at some of that, let's take a look at how this reads a little bit. And I'm going to pull up our simplifier in the back in the job aid section. And let's look at Article 1 and then the first part of that. As I mentioned, all of that information, we're outlining the information 402C, 403A4 for rollovers, 408D3. We're talking about all that and the amount of the contribution. Well, that's might not be easy for the IRA owner to understand that. So when we go down to our disclosure statement, which is going to follow our plan agreement. The requirements of an IRA says we have to make cash contributions. It tells them the maximum amount, who's eligible for the catch-up contribution. So we're giving that in an easy to understand manner. Now, another thing the disclosure statement provides is the right to revocation. So they have the right to revoke that IRA by providing it in writing. So if we take a look at that, it says you have the right to revoke your IRA within 7 days of receipt of that disclosure statement. They can get a full return of their contribution if they do that by providing that revocation in writing within 7 days following the date they establish that. So they can change their mind, and that disclosure statement has to provide that revocation period. So, questions on the non-technical explanation? Okay, our third required document then is our financial disclosure, which is simply a projected future value. Now, when opening that, let me back up just for a moment. Our plan agreement and disclosure statement from time to time has to be amended when we have changes. The disclosure statement will be amended anytime the plan agreement's amended, but also the disclosure statement might be amended when we have law changes and we have to notify the IRA owner of those changes. So we might have to give them an up-to-date disclosure statement. Now, the third document, the financial disclosure, never has to be amended. We only have to provide that at the time that the IRA is established. So we never have to update this, even if they change investments. So the financial disclosure is just providing them with a growth projection of what they might expect to have if they save. Now, if growth cannot be projected because they've chosen stocks or bonds or mutual funds or maybe a variable annuity at a life insurance company, then they have to give a general description of the investments. They have to give a general description of any fees that might apply. They should give them a general description of how earnings are going to be calculated on that, and then any other information that might aid the IRA owner. Now, most of you offer certificates of deposit, so growth can be projected. So under this, we have to tell them what is going to be the value of the IRA at the end of the first 5 years in which they make a contribution. What's the value of the IRA when they reach 60, 65, and 70? And it's based on how they're funding it. If they make a regular contribution or into that IRA, then we're going to base it on an annual $1,000 deposit that's made on the first day of each year, regardless of how much they actually put on there and when they made that deposit. If they fund it with a transfer in or a rollover in, maybe from an employer plan, then our financial disclosure will be based on a one-time $1,000 deposit made on the first of the year. We'll base it on the age of the IRA owner that they attain in the contribution year. We'll describe what the investment instrument is. And then if it's a certificate of deposit, what is the term of certificate? We also have to project this based on an earnings rate that's no greater than what's currently in effect. So if you're paying out at 2% right now, you can't use a 3% rate. You can use anything less than 2%, but it can't be greater. And then we use a compounding method that's no greater than what's also currently in effect. And you should also disclose any loss of penalties on that. So our growth projection We have to tell them what these balances are. Any questions on the financial disclosure? Okay. Back in the job aids 22 and 23, we showed this is what it looks like in the simplifier. If you happen to use IRA Direct as well, this is what would be generated. Walters Kluwer, if you're using those documents in the organizers, theirs looks a little different as well. So we have to give them the PDF, the plan agreement, the disclosure statement, and our third one, F, the financial disclosure. Any questions on those three documents? Okay, let's do a little review. For traditional and Roth, what are the tax advantages for that? Chat that in if you recall what the two tax advantages are for traditional and Roth IRAs. What are the two common tax advantages? Chat those in if you happen to think about it, if you recall. Very good, yes. Tax deferred earnings always, and they might be eligible to take a tax credit. What's the big advantage of traditional IRA funding that? Why might they choose the traditional? What would be the advantage that's only available to the traditional? For that, that would be a tax deduction. And then how about the Roth IRA? What's the big advantage of the Roth IRA? The reason anyone wants that would be for tax-free earnings if they have a qualified distribution. Now, our IRS required documents as a review, our PDF, the IRA plan agreement, our IRA disclosure statement, and our IRA financial disclosure. So those are going to be our three required documents. And then additional documents that you may be using would be the application. So that's what we would do to establish the IRA. Any questions on what you would need to do to assist your customers in getting their traditional or Roth IRA set up? Any questions on that? Okay. So that's our introduction and establishing. Next, we're going to talk about funding. Debbie, do we want to take a short break?
Yeah, I think I have perfect enough time to do a break and still get done before lunch with funding.
Okay.
Can I do about 10 minutes?
Sure, we can do 10 minutes.
Okay, I will share my screen and put up my clock.
Okay. We'll give you all a chance to stretch, everyone.
Well, my timer's not working, so we'll see you back here in 10 minutes. Welcome back. I have 10 minutes, so we're going to go ahead and get started with our IRA funding section, and this will take us up to lunch. Again, my name is Debbie Shipman, so welcome. Everybody should be on page 25 with our learning objectives in our guidebook for IRA funding. And what we want to do in this section is compare and contrast traditional and Roth eligibility requirements. Jeff brought that up a little bit earlier today, that we are talking about those pieces in this section when we talked about tax advantages, and there was going to be some differences. And with eligibility, that's what we're going to cover here. Jeff, after lunch, will get to the differences in distribution. We're also going to explain the regular contribution limit and talk about the difference between, or what the deadline is and the difference between regular and prior year contributions. And then we'll wrap up this section talking about regular contribution reporting deadlines. So to get started, we are on page 26 of our guidebook, and whether an individual wants to contribute to a traditional or to a Roth IRA, they have to have met the eligibility requirements for the particular year that they are contributing for. So if they're going to be contributing for 2022 currently, which we'll talk about is an option, then they have to meet these eligibility requirements for 2022. If they are in turn contributing for tax year 2023, then they have to meet the eligibility requirements for that type of IRA for 2023. Now, in our establishing section, Jeff talked about the documents that are required for establishing and so forth. Anyone can establish an IRA, but they have to meet the eligibility requirements to contribute or put new money into an IRA. So what you'll see on page 26 in that very first paragraph is that anyone who is eligible to open an IRA at the, anyone is eligible to open an account at the financial organization, but they have to meet those eligibility requirements on putting new money in. In order to contribute to a traditional or to a Roth IRA, one eligibility requirement that they have in common is that that individual has to have what's called eligible compensation. And they have to, again, have that for that particular year. Now, there's a number of different pieces out there that are considered compensation, but the IRS only considers a certain few to be considered eligible compensation. And that's what the owner has to make sure that they have for the year that they're contributing for. If they're not sure if they have eligible compensation, one of the things that they could potentially look at, and this is kind of a rule of thumb because some of the eligible compensation pieces don't fall into this category, but they could potentially look at their W-2. So much like, Jeff and I, you guys are probably going to be receiving your W-2 shortly from your employer that indicates your wages for the year. So most of the eligible compensation, again, not all, so it's a rule of thumb, would appear on their W-2. And that would be in box number 1 on the W-2. If they are a self-employed person, they could look to their Schedule C. If they're a farmer, they could look to Schedule F. Now that's, again, a rule of thumb. It's not necessarily an end-all be-all because, as I said, there are pieces of eligible compensation that might not appear in those particular forms, but it is going to be their responsibility to determine if they have eligible compensation. Eligible compensation by the IRS is amounts derived from or received for personal services actually rendered. That's kind of the definition there. So what you're going to see on the screen is all sorts of different sources of compensation, but the IRS doesn't consider all of them to be eligible compensation. So what it breaks down to on the screen or on page 26 in your chart is breaking it into eligible versus non-eligible compensation. In order to contribute to a traditional or to a Roth IRA for a particular year, that individual has to have wages, salaries, tips, bonuses, commissions, professional fees, combat pay, certain payments to graduate students, and difficulty of care payments. So money coming from any of those sources is by definition eligible compensation, and anything that is not from one of those sources would not be. Some examples would be taxable alimony, interest, royalties, dividends, rental income, disability pay, separation and early retirement, unemployment compensation, child support, AFDC and TAMP, and Social Security. Now, the last two on the eligible compensation column have a little asterisk after them. The certain payments to graduate students, that applies in 2022 and later. That came about as a result of the Secure Act that was passed the end of 2019. And then the difficulty of care payments, which is a type of qualified foster care payment, that became eligible for contributions made after December 20th of 2019. And that is, again, the passage of the Secure Act, which was part of the FCAA that Jeff talked about earlier this morning. So those are two relatively new definitions or pieces of eligible compensation or sources of eligible compensation. Again, keep in mind that the note at the bottom of page 26, the owner is the one who's responsible for determining if, in fact, they have eligible compensation and are eligible for that particular year. Now, when it comes to the eligibility rules, source of compensation, that eligible compensation is required for both the traditional and the Roth. And then it breaks down. So we're going to look at just the traditional contribution eligibility on page 27, and then we'll take a look at the Roth eligibility in whole on page 28. So when we are talking about traditional IRA contribution eligibility and just focusing on traditional, it currently has one eligibility requirement, which is eligible compensation. It used to, before the Secure Act in passed effective 2020, it did in 2019 and earlier have a second eligibility requirement, which was age. You used to have to be under age 70.5 and not attaining age 70.5 anytime during the year, plus have eligible compensation in order to contribute to a traditional. That age requirement was eliminated, and now the individual to contribute to a traditional only has to have, for 2020 moving forward, eligible compensation for that year. So my dad, who happens to be 80, let's say he has eligible compensation this year through wages, salaries, tips, bonuses, etc., he could contribute to a traditional IRA, even though he's 80. Now, when Jeff talks in distributions, there is something called a required minimum distribution that they have to start taking at a particular age. My dad is of the age in which he has a required minimum distribution. So if he's eligible to contribute, he can do so, but he would still be required to take that mandatory distribution on the withdrawal side. So he would potentially have money going in as a contribution, and in the same year having money coming out as a required minimum distribution. But what I want to point out with my dad as the example is that if he does in fact have eligible compensation, the fact that he's 80 has no bearing on anything. He has the ability to contribute to a traditional IRA. Now, the eligibility rules to deduct your IRA contribution, and this is in the note on page 27, are not connected at all with your ability to contribute. So if they can contribute, they have eligible compensation. That doesn't mean that they automatically can deduct that contribution, which was one of the tax advantages that Jeff talked about this morning. But they would look to a different set of rules to determine whether or not they can then deduct that contribution. So they're not connected. Those are two separate concepts, and both of them are the owner's responsibility to determine. Now, on page 28, we have our Roth IRA contribution eligibility rules, and here there are two. So nothing changed as a result of any tax laws that have been passed, and in order to contribute to a Roth IRA for a given year, that individual, for whatever year they are contributing for, has to meet both the eligible compensation rule and their modified adjusted gross income, or MAGI, has to fit within a limit. Excuse me. So you'll see on page 28 in the first paragraph there at the top, both is bolded for us, and that's because they have to meet both number 1 and number 2 for the year that they're making that contribution for. So my dad, again, if we use him as an example, if he has eligible compensation, he has one part of that, And then his modified adjusted gross income, or MAGI, has to fit within or below the limits that the IRS releases every year. And those are subject to what we call cost of living adjustments, or COLAs. Now, the IRS puts forth a phase out range. And then when the owner is looking at that phase out range, they're going to look at their modified adjusted gross income. That modified adjusted gross income, or MAGI, comes off of their tax return. It's not something that most folks have readily available. They know how much their MAGI is. I could tell you how much my salary is, but that's not necessarily the same thing as my MAGI or my modified adjusted gross income. That I will have to look to my taxes to get that figure. So what the IRS says in number 2 on page 28 is that if their MAGI, based on their filing status, falls within this phase out range that the IRS sets forth, the owner is going to need to calculate how much they can contribute when they file their tax return. They're going to use IRS Form 8606 to help calculate that. So this is, again, something that the organization isn't going to do, but the owner would do on their own or with their tax advisor. But we could certainly direct them to IRS Form 8606 in the instructions for more information on how to determine their contribution amount if they're within this phase out range. Now, the way in which this works, you'll see the chart for 2022 on the screen and also on page 28 for you, is again based on their filing status and their MAGI. So if, let's say this year I'm a single filer for 2022 for this tax year, my phase out range is 129,000 up to 144,000. And that would be, again, my MAGI. If my individual MAGI falls below the phase out range, so it's up to 129,000, then I can do what's called a full contribution. I can contribute the full amount that the tax laws allow for that particular year for my age. If my MAGI falls between 129,000 up to 144,000, then I am eligible to contribute a partial contribution. This is where I or my tax advisor would use IRS Form 8606 to determine how much I can contribute. Now, I won't be able to contribute the full amount, but I will be able to contribute something, a partial contribution. Generally speaking, from a math perspective, the closer I am on my MAGI to the bottom of the phase out range, the more I'm going to be able to contribute, but not a full amount. The higher I am and the closer I am to the top of the phase out range based on my MAGI for that year, the lesser I'm going to be able to contribute, but it would still be something. Now, if my MAGI for 2022 as a single filer is over the phase out range, in this case over 144,000, then I am not eligible to contribute to a Roth IRA for this year. Now, keep in mind that in order to contribute to a Roth, I need 2 requirements. I need my MAGI to fit either in the partial or the full category, and I need eligible compensation. So if I'm over my MAGI limit for the year, but I still have that eligible compensation, I would be eligible for a traditional contribution because that's the only requirement over there on the traditional side. Now, in all reality, my husband and I are married and filing jointly. So our joint MAGI phase out range is 204,000 up to 214,000 for 2022. If our joint MAGI, so mine and my husband's together off of our tax return, is below the phase out range, so up for 2022, up to 204,000, then I can do a full contribution for the year. Again, full is based on how much I'm eligible to contribute for that particular year. Now, if my joint MAGI with my husband is between 204,000 up to 214,000 for 2022, then I'm eligible to contribute a partial contribution. So I or my tax advisor would use IRS Form 8606 to determine how much that would be. My husband would be in the same situation, so he would also need to complete an 8606 form for his Roth contribution. And we would have 2 in that case attached to our tax return. If our joint MAGI for 2022 is over the MAGI limit threshold, and it was then in this case for 2022 over 214,000, then neither of us would be eligible to contribute to a Roth for that particular year. Now, married filing separately is not attached to cost of living adjustments. That's hard coded into the tax law at this point. So if I am married but filing separately for this year, then I have no opportunity for a full contribution. I have a very small window of opportunity for a partial contribution if my individual MAGI is between 0 up to 10,000. Excuse me. And if my individual MAGI is over 10,000 for 2022, then I am not eligible for a Roth contribution. The phase out range, as I indicated, is attached to cost of living or modified for our cost of living adjustments or COLAs every year. So these numbers will shift. However, the concept is still the same. So whatever the phase out range is for a given year, if you are below the phase out range, you qualify for a full contribution if you're single or married filing jointly. No contribution for married filing separately. If your MAGI based on your single filing status, your married filing jointly status, or married filing separately status falls within that prescribed phase out range, you are eligible for a partial contribution, regardless of what these two numbers are up here near the top. And again, if you are above the phase out range, there's no opportunity for a Roth contribution for that given year based on your filing status. Again, those numbers may change. However, the concept is still the same. So you have full below the phase out range, partial within the phase out range, and you have no eligibility for a Roth contribution over the phase out range. Now, on the bottom of page 28, we have our 2023 numbers for you as well. These cost of living adjustments are generally released in the fourth quarter, usually in mid to late October, so that we know what they are for the following year. So what you're going to see is that they shifted slightly, again, for the single and the married filing jointly. However, the concept is still the same. So if someone is coming in to contribute for 2023, these are the modified adjusted gross income numbers that they may question or ask you about. We as a financial organization are not going to determine if they can do a full contribution, a partial contribution, or no contribution for that particular year, but we could explain the concept and we can also explain how the rules work. It's going to be the owner's responsibility to determine if they in fact are eligible for the contribution based on their own personal information. So the numbers again for this year shifted slightly for 2023 tax year. We have our phase out range for single filing individuals, at 138 up to 153. And our married filing jointly individual phase out range is 218,000 up to 228. Again, you'll notice that the married filing separately didn't change. Again, that's hard coded and not adjusted for cost of living. Any questions on that up to that point at all before we take a look at our spousal contributions? Excuse me. Okay. So we're going to take a look at page 29. And in regard to our spousal contributions, what we are looking at here is an individual where they themselves do not have eligible compensation, or they do not have eligible compensation enough to give them a full contribution for the year, full for whatever they're eligible for, up to their full partial, up to their full amount. So in order to do a spousal contribution, that individual has to be married, filing a joint federal income tax return. The only way that you can do a joint income tax return is if you are married. If it's a Roth IRA, then their joint MAGI has to meet the other eligibility requirement. Remember, if it's a traditional, they only have to have eligible compensation, and that they could potentially be getting through their spouse. But again, with the Roth, they have to also meet that MAGI limit, and that would be based on joint filing. For a spousal contribution, while they may be using their spouse's compensation to get that eligible compensation, they do have to contribute to their own IRA. So if we take a look at my family situation, my brother, Matt, is a stay-at-home dad. And my sister-in-law, Melissa, works, and she is the only one that has eligible compensation in the household. Now, my brother, Matt, who's a stay-at-home dad, all his kids are in school, and the youngest is in 4th grade. So I have no idea why he's the stay-at-home dad any longer, but he is. He himself has no eligible compensation. So if we look at just Matt, without Melissa, Matt alone has no eligible compensation. You need eligible compensation in order to contribute to both the traditional and the Roth. So just by that factor alone, he would not be eligible to contribute to either the traditional or the Roth. Because he is married filing joint taxes with Melissa, he gets to treat Melissa's eligible compensation as his own eligible compensation. Because they're both on the tax return, they're both responsible for the taxes that are due, regardless of who earns the money. He gets to get the benefit then of treating her eligible compensation as his eligible compensation. So now, because they're married filing jointly, he has eligible compensation through Melissa. Based on that information, he would be eligible to contribute to a traditional. In order for him to contribute to a Roth, he has the eligible compensation through Melissa because they're married filing a joint return. But their joint MAGI has to fit the limit. So they would be, for 2023, they would be looking at the phase out range of $218,000 up to $228,000. If Melissa's, because we know Matt doesn't have any eligible compensation to contribute to this scenario, but if their joint MAGI, which is solely in this case based on Melissa, is up to $218,000, then Matt and Melissa can each do a full contribution. If their joint MAGI is between $218,000 up to $228,000, then they can each do a partial contribution, and each Matt and Melissa would complete the 8606 form to determine how much they could each contribute. If their joint MAGI is over $228,000 for 2023, then neither of them is eligible for a Roth. However, they both have eligible compensation, Melissa through herself, Matt through Melissa, because they're married filing jointly, and now they could still each make a traditional contribution if they chose. Now, keep in mind with the spousal contribution, Matt does have to have an IRA in his name. Remember, the I stands for individual, and he would be contributing his traditional or his Roth contribution to his respective IRA, not to Melissa's. Melissa will contribute to Melissa's IRA, Matt will contribute to Matt's IRA. So that's kind of a personal scenario to kind of explain how that works. What we're going to take a look at is the example over on the bottom of page 29 with Daphne and Aaron. And while we're not going to do this in a real life scenario, we do want to do this in training to kind of solidify the information and make sure that we're comfortable and understand how this works. So Daphne is 50 and she has eligible compensation of $140,000. Aaron is 48 and he is currently unemployed with no source of eligible compensation. Daphne and Aaron are married and their joint MAGI for tax year 2023 is $150,000. Now, based on that information, while you wouldn't do this in a real life scenario, would you say, using chat, you can abbreviate T for traditional, R for Roth, N for neither, B for both if you want to go that route. Daphne is eligible to contribute to which IRA type or types? Which type or types? We'll talk about the why, but what do you think from a chat perspective, the type or types that she would be eligible for based on the scenario that we talked about on page 29? Getting a B for both. Getting another B with a question mark. Okay, I do agree it's both. So we're going to take a look. The book doesn't ask why, I ask why in the PowerPoint, so, but there's white space down below. If you want to jot down the whys as I'm popping those up on the screen, please feel free to do so. So we're going to take it IRA by IRA. So she is eligible for the traditional, and the reason being is that she herself has eligible compensation. So remember, for traditional, all you need is eligible compensation, and she has compensation of $140,000. She is also eligible for the Roth. So the both is great because that means that both of them, she's eligible for both in that case. So the B works. And here's the why for the Roth. So she has eligible compensation. We know that she has 140,000 in eligible comp, and her MAGI falls below the income limit. Now the top of her phase out range, and we were looking at 2022 or 2023, excuse me, as you recall. So we're looking back at 2023. So if we're looking at that phase out range for 2023, that is 218 to 228. Okay, back on page 28 for you. So if her MAGI is below 228, because she's married filing jointly, she can do a contribution. Now, partial if she falls within the phase out range, full if she falls below the phase out range, but just in general, if she can contribute, which is the question that we're looking at, is that it's a yes, because she has eligible compensation for 23 and her MAGI, excuse me, falls below the income limit, which is the top of the threshold, which is 228. So she's at least eligible for something. So B for both. Now we're going to take a look at Aaron. Aaron, as you recall, is unemployed. He's 48, no sources of eligible compensation himself. He is married filing jointly with Daphne. Based on that information, again, not in a real life scenario, just in training, would you say he could do the traditional, the Roth, neither, or both? So T, R, N, or B? Let me know through chat what you guys think about Aaron. I've got an R. Okay, I don't see any more takers in chat, so let's take a look. He can do the traditional, and here's why. And again, use the white space if you would like to use the white space for the whys. He has eligible compensation through Daphne. Remember, they're married filing jointly. So Daphne's eligible compensation is now Aaron's eligible compensation. So while he does not have eligible compensation independently, he does have that married through his spouse. So he can do a spousal contribution, which is tracked exactly the same as a regular contribution on your end. There's nothing different from a reporting perspective, a tracking perspective. It's just a contribution as far as you're concerned. He can also do the Roth IRA because he has eligible compensation through Daphne. Remember, he's using her eligible compensation of 140,000 as his own. And their MAGI, their joint MAGI, falls below the income limit. Again, jointly, they're 150 on their MAGI. Doesn't matter whose that really is to per se, although we know it's Daphne's in this example, they share it, so it's theirs. And again, if they're below the top of the joint MAGI phase out range for 2023, which is 228, he's a yes. Okay. Specifically speaking, if he's between 228 on their joint MAGI up to 218 up to 228, he would be a partial. And if he is below the phase out range or up to 218,000 for 2023 on their joint MAGI, then he'd be a full. But just in general for this question, he's a yes, he can do both the traditional and the Roth because he does meet both of the requirements. Eligible compensation for the traditional, eligible comp, and the joint MAGI falls below the MAGI limit for 2023 for the Roth IRA. So he can, in fact, do both there. Questions on how that functions before we talk about the actual limit? How much is a full contribution? When I say full, what do I mean? Any questions on that? Feel free to unmute your phone or send the question through chat. Okay. So what we have for you on page 30 is some discussion around the regular contribution limit. Now, keep in mind that the limit we're going to talk about is a traditional and Roth IRA aggregate or total limit for the year. So the limit that we speak of is not the traditional limit or the Roth limit. It is a combination of the two. So if they qualify for a contribution, it's not that you can do that much to a traditional and that much to a Roth. It is that is the amount that that individual can contribute to all of the IRAs that they're eligible for max for the year. So I like to look at that as a taxpayer limit. So whatever they determine their annual limit is for the year, that is the amount that that individual can contribute across the board, regardless of how many traditional IRAs they own, regardless of the number of Roth IRAs they own, or if they own both types. That is still an individual limit. Because it's an aggregate limit or a total limit for that individual, they can contribute that full value to a traditional if eligible, or to a Roth if eligible, or some to both if they're eligible. So it doesn't matter what type of IRA that limit goes into, as long as that individual is eligible for that IRA type based on those eligibility rules that we just discussed. But they can't contribute that same amount to all of their IRAs. It's an individual limit or a taxpayer limit. Now, the IRS says in the first bullet point that that amount is going to be potentially adjusted annually. And again, those cost of living adjustments or COLAs are usually fourth quarter, or our fourth quarter, usually mid to late October is when we see those. And those regular contribution limits at this time, if inflation adjusts enough, will be increased in a $500 increment. That limit for the year in that first bullet point on page 30 is that the owner can contribute 100% of their eligible compensation up to the limit. So it's the lesser of the two. So Daphne had eligible compensation for this year of $140,000, but her limit is going to be the lesser of $140,000 or the regular contribution limit for that particular year. Okay. Now, Aaron, same scenario. The IRS says that the limit for the year for 2022, because you could still make a 2022 contribution, and we'll be talking about that in just a little bit, is $6,000. That's again, traditional Roth combined, individual limit of $6,000. You have to have at least $6,000 in eligible compensation for 22 in order to contribute that amount. If this was Daphne in 2022 and she was at $140,000, don't look at her age yet, then 140 versus 6,000, 6,000 would be the lesser of the two. Okay, so then that's what you'd be looking at. If we look at, let's say, a individual who only earns $4,000, okay, that's their total eligible compensation for the year is $4,000. Okay, no married filing jointly, single filer, nobody else that they can rely on at that point. Their eligible comp is $4,000 for 2022, and the limit is $6,000. So it's the lesser of the two, and they can only put in the $4,000. Again, this is the owner's responsibility. At a financial organization, we can accept the maximum for the year based on that individual's age. If they're not eligible for that amount that they contribute, because they've put in more than their eligible compensation, for example, that is their responsibility. For 2023, we did see that increase by $500, and that will be for this year $6,500. So as long as you have at least $6,500 in eligible compensation, you would be able to contribute that full amount there. So when we looked at page 28 and we said full amount partial, that full amount is going to be $6,000 or $6,500 in that example. Okay. Now, in the second bullet point on page 30, we talk about the catch-up contribution. And this is truly where Daphne is going to fall, because Daphne is actually 50 or older. So if an individual is 50 or older in a given year, they are allowed to do what's called a catch-up contribution. And that catch-up contribution is currently $1,000. And that is currently not adjusted for inflation. For 2022, if they're contributing for 2022 in Daphne's situation, then she would be able to contribute $7,000. It's the annual limit plus the catch-up for a total of $7,000. She has to have at least $7,000 in eligible compensation for the year in which to do so, or it's the lesser of the two values. Now, Daphne's really 2023 in our example, but she is 50 or older. So she would be able to put in the $6,500 plus $1,000 for a total of $7,500. Now, again, that's assuming that she has $7,500 in eligible compensation for the year, which we know she does from our example, but again, that's going to be Daphne's responsibility. Now, Aaron is not yet 50, so he would not be able to do that extra catch-up contribution. And again, that is currently a flat $10,000, or excuse me, a flat $1,000. It is currently not adjusted for inflation for tax year 2022 or 2023. Jeff had mentioned the passage of Secure 2.0, which passed December 29th of 2022. So very recently, one of the parts of the Secure Act, it doesn't take effect until tax years after 12/31 of 2023. So it doesn't affect current year, but it will affect going forward, is that the catch-up amount, this $1,000 that's currently a flat, non-indexed for inflation or cost of living of $1,000, that will be indexed in taxable years after 23, after December 31st of 23. So that number will potentially change moving forward, but it's not for 2022 or 2023. So I just want to point that out in case you get questions on that amount being changed or indexed. That is something that it has been passed as part of Secure Act 2.0. But it will not take effect in 2023. It takes effect for taxable years after December 31st of 2023. So just kind of a heads up on that. So we are going to take this information, and I kind of added Daphne into this. So looking at page 31, we should be able to get some of that information, hopefully relatively seamlessly, but we're going to take a look at it nonetheless to make sure. So Daphne, again, nothing's changed here. She's 50. She has eligible compensation of $140,000. Aaron is 48 and is currently unemployed with no source of eligible compensation. Daphne and Aaron are married, and their joint MAGI for tax year 2023 is $150,000. Now, how much can Daphne contribute for 2023? Using chat, what do you think based on her information and what we've looked at, pulling all those pieces together? What is the amount that Daphne could contribute for 2023? Let me know what you think through chat. Okay, I'm getting 7,500. Perfect. Okay, and here's the why. You have some white space if you wanted to jot down the why, but she is eligible for 7,500. Because again, she has eligible compensation, so we know she can contribute. We know she fits the limits for the Roth, so she can choose either type, it's fine. But her limit across the board, whether she chooses to put any into a traditional, any into a Roth, she can split the difference, she can do uneven values, she can put it all into one type, however she wants to, but she is limited to 7,500 across the board. And that's because she's 50 or older, or will be 50 or older by the end of 2023. So even if she's 49 today, if she's going to be 50 on or before December 31st of 2023, she could do this catch-up contribution. So she is eligible for the $6,500, and she's eligible because she's 50 or older for the extra $1,000 for a total of $7,500. So to kind of give you an example of turning 50 sometime during the year, this past year in 2022, in July, I had my 50th birthday. So the first 6.5-ish months of the year, I was 49. I could still contribute the extra $1,000 to my IRA. Now last year was $6,000 plus $1,000 for a total of $7,000. So I could contribute a total of $7,000 in February, even though I was 49 and I would not attain age 50 until July. Because as long as you are going to be 50 by December 31st, on or before December 31st of 2022, you would qualify for this catch-up contribution. So now this year, I'm already 50, so it's really kind of not an issue as far as trying to figure that part out. But last year, when you're 49 part of the year and 50 part of the year, you can still contribute while you're 49, that extra catch-up amount, because you will be 50 by the end of that year. So in Daphne's case, it is 7,500 because of her age. And again, she has the 140,000 in eligible compensation. So it's the lesser of the two, and the lesser of the two is the 7,500. Now with Aaron, we know he can contribute to either the traditional or the Roth because he's using Daphne's eligible compensation as his own and their joint MAGI for the Roth. But how much, using chat, do you think Aaron is eligible for 2023? Okay, I've got a 6,500 coming in. Okay, so that is 6,500, and here's the why if you want to jot that down. Remember, he has eligible compensation through Daphne. Remember, that's where he's getting that. He doesn't have any of his own, but he's married filing jointly, so Daphne's eligible compensation is his own eligible compensation. And he is under 50, he's 48. So he is only eligible to contribute the full amount for the year, not the full amount plus the tax catch-up contribution. So he's only eligible for 23 to do 6,500. Now, again, he has to have at least 6,500 in eligible compensation, his own or through Daphne, because he's married filing jointly. Their joint MAGI is 140,000. He has to do the lesser of the two. Now, because they're married filing jointly, their joint eligible compensation is 140,000. The two contribution maxes in this case are going to be a total of 14,000. They have to have combined, because they're married filing jointly, at least 14,000 in eligible compensation for the year in order for them both to max it out. So if they only, let's say, combined had $10,000 in eligible compensation, Daphne could do 7,000 and he would only be able to do 2,500, which would be enough to get them up to the total of 10. So they would have to split the difference. They wouldn't be able to each do the full because they don't have enough eligible compensation between the two of them to do that. Again, this is going to be Daphne and Aaron's responsibility. It's not going to be the financial organization's responsibility to determine how much they're eligible for, but you can safely accept no more for Daphne than 7,500 based on her age and 6,500 for Aaron based on his age. It is their responsibility to make sure that they can contribute those dollar values should they choose to do so. Again, keep in mind for each of them, since they're eligible for both types of the traditional and the Roth, this is going to be a combined limit between the two. So Aaron, looking at him as an example, is not eligible to do 6,500 to a traditional and 6,500 to the Roth. It's Aaron is eligible to do 6,500. He can split it and put some into each type, or he could do all into one type versus the other. That's going to be his decision to do. Questions on regular contribution amounts, eligibility requirements, anything that we've looked at up to this point? Okay, I'm not hearing anything and I'm not seeing anything coming in through chat. So we're going to take a peek over at page 32 and we're going to talk about our regular contribution deadline. Now, the IRS says that you can make what's called a current year contribution, the year that you're physically in. So 2023, for example, regular contribution beginning on January 1st of that particular year. So as of January 1, 2023, you could start contributing for 2023. Now, we all know that we're probably not open on the 1st. I believe that was a Sunday. So we might have even had Monday off. I can't remember the calendar already. It's only been a few weeks and I already don't remember exactly where that date fell. But nonetheless, that is what the IRS said, is that you can contribute beginning January 1st of a given year for that particular year. The deadline to contribute for any given year is the tax return deadline of that particular year. So if we look at our timeline that I have on page 32 or on the screen, if we put some years around that, If we say the first January 1 that you see over on the far left of your timeline is 2022, and the second January 1st is 2023. As of January 1, 2022, you could start making contributions for 2022, okay, the fiscal year that we were in at that particular point. As of January 1st, 2023, you can start making contributions for 2023 or current year 2023 contribution. Because you have until the tax deadline to contribute for a particular year, that means that in the beginning of that following year, in 2023 in this case, you have until generally April 15th in order to contribute to the prior year or do what we call a prior year contribution. I've also heard carryback, so you might hear that terminology as well. Now, keep in mind in the first bullet point on page 32, this is generally April 15th. So if April 15th falls on a Saturday, Sunday, or legal holiday, we are going to go to the next business day. So one of the things to kind of keep in mind is that that is going to happen for this particular tax year. So if we are looking at 2023, let me go ahead and bring a calendar up here really quick. Okay, so here's 2023's calendar and here's April. So April 15th is our general tax return deadline. Because it's a Saturday, Sunday, or legal holiday, we would then move to the next business day. So normally you would say, hey, that's Monday, the 17th of April. However, April 16th in the District of Columbia, where the IRS is located, is Emancipation Day, and they are closed on April 16th or whatever date it is recognized. Because April 16th is a Sunday, it is being recognized as a federal holiday, and the IRS is then closed on the 17th of April, which makes this a we are still working, but it makes it a federal holiday for a non-tax deadline perspective. So it will bounce to April 18th. So the IRS has set our deadline for 2022 IRA contributions is going to be the 18th of April of 2023. So keep in mind that in that first paragraph on page 32, at the last sentence, it says generally April 15th. But then in that first bullet point on page 32, if it is a Saturday, Sunday, or legal holiday, then it goes to the next business day. And that is happening for tax year 2022 because April 15th is a Saturday, April 16th is a Sunday, which then is being recognized in DC on the 17th, which takes us to April 18th. So you can accept 2022 IRA contributions through close of business on Tuesday, April 18th. When that shifts back, depending on the calendar, again, Saturday, Sunday, we'll have a leap year in there, which will bump us out. If it lands on a standard Tuesday and there's nothing federally declared about that particular day, then it's going to just be the 15th of April. So that's where it generally will land. But I want you to know that this date is going to be April 18th, this coming April for 2022's deadline. Now, the second bullet point on page 32 at the top, the deadline is not extended if the owner has a deadline extension to file their taxes, excuse me. So if they have an extension beyond April 18th to file their 22 taxes, that does not give them an extension to contribute. The deadline to contribute for 2022 will be April 18th of 2023. Now, as far as prior year contributions go, as we're moving down on page 32, Treasury regulations tell us that the prior year contributions have to be in writing. Now, what you accept as in writing is going to be a business decision, but a form, a census, we're going to look at a form in just a moment. Census offers a contribution form that you can use for tracking the contribution. They sign it. That is in writing. I have used a deposit ticket before as in writing. Prior to coming to a census, I've worked in both banks and credit unions and branches and in call centers. And I've been here now 23 years, but I've used deposit tickets in the past. I personally mail my IRA deposit to an organization a couple hours away from where I'm at. And so on my check, I have the date, the dollar value, my signature, and in the memo line, I indicate 2022 IRA contribution. That has constituted in writing for that financial organization. They keep a copy of that check as my in writing. So that will work. If you do not receive something in writing, then you have to code that as a regular current year contribution. So if I don't indicate prior year on the form, on the deposit ticket, on the check, so let's say on my deposit ticket, I just write IRA contribution, or on my check, I just in the memo line write IRA contribution, or I don't put anything that indicates 2022, in this case, IRA contribution, then you're going to code it as a 2023 IRA contribution. Once I allocate a contribution to the prior year, it is irrevocable. So let's say that I come in and I make a contribution in writing for 2022, and I do that today. And then I realize tonight that I've already done a 2022 contribution at my other financial organization's IRA. So I come back into you tomorrow and I say, hey, you know what, that contribution that I made yesterday really should be for 2023. Can you change it? The answer is no, it's irrevocable. This would be true even if it was the same day. Once you allocate it to the prior year, it is irrevocable and it cannot be changed to the current year. That doesn't mean that the owner can't potentially handle it in a different manner. Let's say an excess contribution, which if you're going to be with us tomorrow, Jeff's going to talk about excess contributions tomorrow. That potentially could be handled in that fashion, but it can't just be changed from 22 to 23. Those are irrevocable. Prior year elections are irrevocable. Now, as I said, I do mail my contributions in to my organization that's a couple of hours away from me because going there is just not convenient for me. So I mail those in. It is considered timely if it's postmarked by the deadline and includes written instruction. As long as it includes those two things, the postmark is on or before the tax deadline and it includes written instruction, even if they receive it after, let's say, April 18th, if I'm looking at 2022 contribution, they could still code it as a 2022 IRA contribution. So that's going to be perfectly fine. What I would recommend, because the ink on the postmark does kind of dissipate after a while, I would recommend that you photocopy the envelope as well as the written direction, the letter that's included in the envelope, the deposit ticket that's included in the envelope with the instructions, the check that's included in the envelope. I would document both of those, photocopy both of those and put them in the owner's file so that you have documentation of that. Even if you complete a contribution form for your internal organization for documentation, I would then attach a copy of the envelope and the written direction that you received to that form. On the signature line, you can simply write per attached request. Something along those lines if you want to do it that way. But it is timely if it's postmarked by the deadline. Now, the other thing that I want to point out, because this is another way in which a lot of folks do contributions, is through direct deposit. On the bottom, page 32, direct deposits just come in every week, every other week, once a month, depending on how they're scheduled. Because of that, direct deposits we recommend are coded as current year contributions. Unless you have written instruction prior to receiving that contribution, that it should be a prior year contribution. Most organizations, from what I have found out in working with them, will do only current year contributions for direct deposit. If you want to do a prior year contribution, you need to come in and physically do that or mail them something that is postmarked and elected in writing. The reason that I've heard that from financials is what they've told me is that their system, it's too cumbersome for them to then say contributions received on this date, and this date count as prior year, but this date going forward count as current year. It's too much for them to follow. And it's generally not the IRA person that's working with those direct deposits. So they have those all set up for current year contribution. If you are going to allow prior contribution through a direct deposit, we recommend to have that written instruction prior to receiving that information. Now, as I said, you can use a form as your written direction. We do have a copy of the Essentials form on page 33. Now, that might look a little different than the form that you're using, depending on the forms vendor that you're working with, but this is what a census looks like. Very similar to the application that Jeff showed us earlier. We have our part 1 of our owner, part 2 of our financial organization, and part 3, I have popped out just a portion of that for us here that we're looking at. This is all about the regular contribution. So the rest of part 3 is we'll look at in portability this afternoon. So here's where the individual can enter the dollar amount that they're contributing, the date that they're contributing. They can also then mark that it's a regular contribution and include the tax year. This is where they can allocate in writing. They would then sign the form. Now, signing the form is all you need from a legal perspective. If, let's say, I come in and I say, hey, I want to make a contribution for 23, and you put 23 on here, you put the dollar amount because you're filling perhaps this form out for me, today's date, and you say, hey, Debbie, go ahead and review the form and sign it for me. I sign the form, I come back later and say, no, this was supposed to be a prior year contribution and you got it wrong. Here's what I would recommend, whether it goes either way. I would say if you're filling out the form, and this is my recommendation only, you're filling out the form, whatever form you use, for a prior year contribution, or really anything between January 1 and the tax deadline, is that you ask, Debbie, can you sign that form? And can you initial the tax year for me to make sure that we got it right? This forces me to read the form. When I then come back in, and I know that this has happened because I have had clients who I've talked to about this, given them this recommendation, and I've actually seen them in later training sessions where they've actually told me that they've done this and that it actually worked, because they had a person come back and challenge the fact that they said that this contribution was not for the prior year. And they said, well, you signed the form, but you also initialed the fact that it was for 2022. Now, where do I go? There's nothing I can do. I initialed the tax year that it was for prior year. And again, prior year is irrevocable. So I'm kind of stuck. So I would recommend that you have them initial the tax year just so that you force them to make sure that that's correct, because I've written down 2022 a couple of times already this year and it's 2023. So it happens to the best of us. Questions on any of that before we look at an activity and then wrap up with our reporting? Okay, so we're going to take a look at page 34, and we are going to pretend that today is March 14th of 2023. Ryan, who's 51, would like to make a contribution to his IRA. Using chat, for what year or years can he make the contribution? And why do you think that? I'm getting 2022 and 2023. Both years, both current year, prior year in that case. And that's correct. So he can elect because it's before April 15th. Perfect, thank you, for the prior year. So I have it up here if you want to jot it down on page 34. This is one of the answers that is activities that is in the back of the book Jeff noted earlier. So if you don't want to write it all down, it is going to be back there for you. But don't cheat and look back there before you try and answer the question. So Ryan can elect either tax year 2022 or 2023, in this case, both, or either, depending on his scenario, because it's between January 1 and the tax deadline. Again, that's generally April 15th. In this case for 22, it is going to be April 18th, to be more specific in Ryan's particular scenario. Now, number 2, does Ryan need to give the financial organization written instruction for the contribution? What do you guys think through chat? Does he have to give you written instruction for the contribution, or for either one of the contributions? Only if it's for 2022, for 2022, yes. Perfect, thank you. So Ryan only has to provide written direction if he makes a prior year contribution. Now, it is your business decision how you want to handle documentation for current year contributions. The IRS does not require current year contributions to be in writing. Most financial organizations will have you complete a form similar to what was on page 33 at any time during the year to document the contribution. You may choose to document current year contributions only between January 1 and the tax deadline. So there's no confusion between that and prior year. You may choose to document current year contributions all the time, no matter when it is, so that you have a completed form with the owner's election, even though in October there's no choice. Okay, that might be your business decision, and that's okay. You might not require any written instruction, any form for current year contributions, and the IRS says you don't have to. From an operational perspective, you probably do require a form. That's what I have found out, having worked in financial organizations myself and worked with financial organizations for the past 23 years, but it is your prerogative on current year. Prior year does have to be in writing in some form or fashion. In number 3, if Ryan mailed in a contribution and it's postmarked April 14th of 2023, but you don't receive it until April 21st of 2023, can you still apply it to tax year 2022? What do you think? You can if it's postmarked prior to the deadline, and I agree, it has to have written direction. So we know it was postmarked before the deadline, so that's a yes, but it also has to include written instruction inside that envelope. So if there's a check or a letter or a note that says, hey, you know, transfer $1,000 from my checking to my IRA for 2022, that's writing. And that can be, again, with the postmark situation, that can be allocated to prior year. Even though it's postmarked April 14th and you receive it April 21st, but inside the envelope, it says transfer $1,000 from my checking to my IRA. That's a 23 contribution. That's a current year contribution. There's nothing in writing that allocates it to 2022, and you have to have that to allocate it to 2022. And you can't allocate it now. It's April 21st. It's after the deadline. Okay. If Ryan receives an extension to file his 2022 federal income tax return, does that extend his deadline to make a regular contribution for 2022? What do you guys think? Yes or no? Correct. It does not. So he still has the deadline of April 18th for 2022. We know the 18th because of that calendar visual. So looking at reporting of contributions on page 35, this is going to be out to the IRS by May 31st. And this is going to be done on a 5498 statement for that particular year. In this case, it is going to be the 2022 tax year that we're going to be reporting for by May 31st of 2023. Now, this is then sent to the IRS after the tax deadline. The owner will also get a copy. We'll look at that. It's called an account statement. They'll get the same information also by May 31st, which is after the tax deadline. So this is going to cause folks to question or call and say, hey, just got this tax statement, but I already filed. What do I do? If you reported it on your tax return accordingly, nothing. Otherwise, you may have to do an amended return. But the deadline is May 31st because the owners have until generally April 15th, in this case, April 18th, to make contribution. This is used for both traditional and Roth contributions. However, they are going to be separate. So they will get two 5498s if they've contributed to both a traditional and their Roth IRA for that year, assuming they just have those two IRAs, one of each type, and they've contributed to both. So the same form will be used, or I should say same form type will be used, but they will get a respective 5498 for each type. If they have contributed to a traditional IRA, that amount, whoops, I clicked one too many times there, that amount will be in box number 1 if they contributed to a traditional. For a traditional IRA, then you will also, excuse me, I guess we're going to talk about Roth. I forgot where I clicked next. If it was a Roth IRA that they contributed to, that amount would show up in box number 10. Box number 1 and 10 will never be completed on the same 5498. One is for traditional contributions, one is for Roth contributions. So whatever type it's contributing to, the owners contributed to will show up either in 1 or in 10, okay? For both of them, you will then use box number 5 to report the balance of the IRA at the end of 22, in this case, of the traditional, or on the Roth version, you would be looking at the balance on the Roth IRA at the end of 22, because this is the 22 tax statement. It would be the balance on December 31st of the year listed on the form. So again, traditional on one, Roth on the other, but respective balance would go in box number 5. Respectively on their forms, if it's a traditional 5498, you will mark box number 7, IRA box. If it is a Roth 5498, you will then in box 7 mark the Roth IRA box. Again, not marking both of them because we're only doing one type per form, but it would then be either the IRA box or the Roth box. So on the traditional, it's going to be 1, 5, and IRA box 7. And on the Roth, it's going to be 5, Roth box in 7, and 10. Now, as I said, the owner is going to receive the same information, and it's what's called as an account statement on page 36. This could be the actual 5498. It looks exactly the same as what the owner or the IRS receives. It could be something different. It just has to contain the same information, but it doesn't necessarily have to look exactly the same. That's going to be your organization's responsibility to determine that, decide that when you're working on your reporting. But the deadline to the owner, as I mentioned, is also May 31st. Now, if May 31st falls on a Saturday, Sunday, or legal holiday, you will go to the next business day. So I have seen that be June 1st or June 2nd before. And again, it's just about how the calendar falls. Also, what the financial organization has to do is to do what's called a fair market value statement. And this is sent to all of the IRA owners and beneficiaries who have a balance at the end of the prior year. And this is sent by the end of this month or the end of January for the balance of the IRA, whether they're an owner or whether it's an inherited IRA as a beneficiary, as of December 31st of 2022. In this case, will be sent by January 31st of 2023. So you're in the process of working on those at this particular juncture if they haven't already been sent out to your clients. This does not go to the IRS. Remember, we use box 5 in May on the 5498 to tell the IRS what the balance was. So we don't send this to the IRS also. This is an owner or beneficiary only statement. Questions on any of that before we look at our running review? Okay, I'm not hearing anything and I'm not seeing anything. So we're going to take a look at our running review on page 37. And keep in mind, we looked at this with Jeff before at the end of our last section. So we are now moving over to funding. The top portion of page 37 has been filled in for you to kind of match up with what you and Jeff talked about at the end of our last section, our introduction and establishing section. And what we're going to do here is just kind of build on that job aid. So at the end of the day, you're going to have that job aid that you can kind of refer back to with the differences and the similarities between the traditional and the Roth IRA based on the concepts that we're talking about throughout today. So when it comes to regular contributions for a traditional and a Roth IRA, there's one eligibility requirement that they have in common. Using chat, what is the eligibility requirement that the traditional and the Roth have in common? They both require what in order to contribute? Okay, so this takes us to eligible compensation, and that does, if you want to make a note on your job aid, take you back to page 26 in the guidebook. Thank you for your answer. So that takes you back to page 26 in the guidebook if you need more information on that. Now, the traditional IRA does not have a secondary requirement. So while it is blank in your book, you can just pop in an NA because the only requirement for traditional is eligible compensation for that particular year. The Roth, on the other hand, and with the NA, that goes back to page 27. If you would like to jot that down, that's where that takes you for the traditional eligibility requirements. Now, for the Roth IRA, what using chat is the secondary requirement in addition to eligible compensation that an owner has to meet in order to contribute to a Roth for a particular year. Thank you. MAGI limits or income limit, however you want to jot that down in your book. And that takes you back to page 28 in the guidebook. If you want to jot down the page reference, income limits, those MAGI limits, those are talked about on page 28 as a reference point. Now, the annual limit for 2023, okay, you're going to see on page 37 in your job aid, it says list the 2023 limits. So the annual limit that you can contribute, the full amount for under 50 folks, is how much? Perfect. Okay, that's 6,500. And what is the extra amount? Not the total, but the extra amount that you can contribute as a catch-up for age 50 and older folks for 23. Perfect, 1,000. Now keep in mind that that $1,000 will be indexed for taxable years after December 31st of 23. So for this year, it's still $1,000 or a total of $7,500 for me. I'm 50 or older, okay? My brothers are all 6,500 at this point in time. Now that does, if you want to jot down the page reference, that does take you back to page 30. And then we're going to take a look at our deadlines. So what is our deadline for the fair market value statement to be sent to the IRA owner? By when do we have to have the F or beneficiary? When do we have to have that sent out? What date on the calendar? For fair market value statement, that's going to be the end of this month. But May 31st is a deadline that we're going to look at in just a second. Whoops, I skipped a question. That was my own fault. We'll pop it in and then we'll come back. So the deadline is the tax return deadline, generally April 15th. That takes you back to page 32. Keep in mind this year, using chat, what is the deadline for the 2022 tax year? Using chat. April 18th. Okay, thank you. So on page 32, keep in mind in that first bullet point, if April 15th falls on a Saturday, Sunday legal holiday, it will go to the next business day. That is happening in April. So it will be April 18th of 23 for 2022. Generally speaking, and I apologize for skipping that question on the chart, the contribution deadline is generally April 15th. It's the tax return deadline that you can really say specifically. However, the next question was the FMV statement, and that goes out to owners and beneficiaries by January 31st. That associates to page 36. However, our Form 5498 is due to the IRS by May 31st. I saw that come in on a chat answer earlier. So that is due by May 31st. That is corresponding on page 35, if you're taking down page reference notes. And the account statement, which is the owner's contribution information. It can be the 5498 look exactly the same as what the IRS is receiving. It can look completely different. As long as it contains the same information that the IRS is receiving. That is also May 31st, and that is on page 36 as a page number reference. So with that, we have finished up our funding section, and we are going to go ahead and take a 30-minute lunch, and then we will be back at 12:30 your time, and we will pick up with IRA distributions at that time. Any questions at all, please feel free to unmute your phone or send them through chat, and Jeff and I will catch those over lunch, and we will bring up the answers when we get back. We'll see you guys in a half an hour.
Welcome back, everyone. Hopefully everyone had a nice little break there and was able to get some nourishment. We covered an awful lot this morning. I started out with an introduction to IRAs. We talked about the plan establishment process and the tax advantages. Recall with traditional IRAs and Roth IRAs, the earnings are always tax deferred. And then if they contribute to a traditional or Roth based on their tax filing status and where their income falls, they might be eligible to get that tax credit. And recall, tax credits are always good because that actually reduces the tax owed to the IRS. For traditional IRAs, they may be able to take a tax deduction if they make a contribution. That's generally based on if they're an active participant in an employer plan, or if they're not, but they're married, their spouse is an active participant, and where their modified adjusted gross income falls. So that's generally recommend they talk to their tax advisor if they get the deduction. They can always make a traditional IRA contribution even if they don't get the deduction. Those non-deductible contributions do need to get tracked by the taxpayer. They track those on IRS Form 8606, non-deductible IRA contribution form. That way, when they take withdrawals later on, and we're going to talk about distributions next, that portion is not subject to income tax. So we'll look at that when we talk about the distributions. With Roth IRAs, the big advantage is all those tax deferred earnings that are growing over the years. If they have a qualified distribution, those earnings can be withdrawn tax free. So we're going to talk about that as well. We discussed the required documents that the IRS says you need to provide to the IRA owner when they establish their IRA: the PDF, the plan agreement, the disclosure statement, and the financial disclosure. The plan agreements, the contract, the disclosure statement, just simply being a non-technical explanation of those rules. And then our financial disclosures, the growth projection. And then Debbie talked about funding IRAs. In order to make contributions to an IRA, generally someone has to be working and have eligible compensation. So she described what types of compensation are considered eligible compensation. So we need to have that to contribute to a traditional or Roth. Roth, of course, can restrict the amount of the contribution and they may only be able to make partial contributions if their income hits a certain level. And also, once they have income high enough, they might not be eligible to make that Roth contribution. So we do have that requirement as well for Roth IRAs. We can contribute $6,500 as a regular contribution. This year, those getting closer to retirement can make those catch-up contributions. Debbie did mention that next year, that catch-up contribution of the additional $1,000 will be subject to cost of living adjustments due to the Secure 2.0. The deadline to make it is the tax deadline, not including extensions. So we looked a lot at the funding as well. And then those do get reported on Form 5498. Debbie talked about the tax reporting for reporting those contributions to the IRS. So they do know what is being funded each year, as well as what the end of the year balance is, called the fair market value. So we covered a lot this morning. Now that we've kind of walked through the establishment process, talked about funding it, in other words, making those contributions to save for our retirement, we're going to talk about distributions next. When can they withdraw their money? So let's take a look at our learning objectives on page 39 of your guidebook. we're going to identify the federal income tax withholding requirements. Withholding simply is prepaying the income tax, so we'll talk about that. Because they are their own personal retirement savings vehicles, they really can withdraw these monies at any time. And because of that, and since they are intended to be used to provide retirement income later in life, if they take monies out early, they are subject to an early distribution penalty tax. We're going to discuss what exceptions may be available to the IRA owner if they need to withdraw monies early. We'll describe the tax consequences of withdrawing from a traditional IRA and a Roth IRA. For traditional IRAs, because they are tax deferred and we haven't had to pay income tax on it, the IRS says you have to start withdrawing money and paying taxes on those distributions once you reach a specific age. That age now has been increased to age 73 beginning this year under Secure 2.0. That's referred to as a required minimum distribution. And we'll define what the required beginning date, the deadline to remove the first one is. And then we'll also discuss some of the reporting deadlines because we do have to report these distributions not only to the taxpayer so they can apply those appropriately on their 1040, the individual income tax return, they do also get reported to the IRS or Internal Revenue Service. So we'll discuss what those reporting requirements are. So that's what we're going to look at next. But before we get started, does anybody have any questions so far on what we have covered? If you have a question, the best way to ask that is simply unmute your computer or type it in the chat feature. Any questions at all? Okay. So let's talk about withdrawing money out of IRAs or taking a distribution. So really we can withdraw these assets out of IRAs at any time for any reason. Unlike certain employer plans, such as a 401k plan and some of these qualified defined contribution plans, you can't access those funds until you have a distributable event. But because individual retirement arrangements, traditional IRAs and Roth IRAs are personal savings vehicle to provide that retirement income, the individual can withdraw those funds at any time simply by coming into your bank and requesting that distribution. Now, because they are tax deferred savings vehicle, there's two types of taxes that these distributions may be subject to. Income tax, so when they're withdrawn, if it's subject to income tax, it's simply treated as ordinary income. So withdrawals out of these IRAs, traditional and Roths, the taxable portion of these withdrawals are treated as ordinary income, and then they have to pay income tax based on whatever their own individual income tax rate is. And that's based on all other incomes that they're reporting to the IRS. Now, because they can withdraw those at any time, they may be subject to an additional tax of 10%. We refer to that as the early distribution penalty tax. And the early distribution penalty tax will apply to the taxable portion of withdrawal out of a traditional IRA or Roth IRA if it's a non-qualified distribution, and they happen to be under age 59 and a half. So 59 and a half is kind of our retirement age, if you will, assigned in the tax code for when individuals are subject to an early distribution penalty tax. In other words, they're taking it out early. Once they reach 59 and a half, then they're considered under the law to have reached retirement age and are no longer subject to that early distribution penalty tax. So because they can take it out for any reason, depending on the situation, it could be included as income, treated as ordinary income, subject to income tax. And if they take it out early, an additional 10% early distribution penalty tax. So what's the procedure for taking withdrawals? Well, if someone wants to take money out of their traditional IRA or their Roth IRA, they're going to contact your bank. And then they'll tell you how much they want to take out. So a good thing is to give them a distribution notice when they come in, and so they can tell you how much they want to have distributed out of their IRA and what that reason is for. And we need that reason for tax reporting purposes. So they need to tell you why they're taking it out. Maybe they're under 59 and a half. It's an early distribution. Maybe they've already reached 59 and a half and now it's a normal distribution. Or maybe from a Roth IRA, it's a non-qualified distribution or qualified. We're going to define what those are. Now, because distributions could be subject to tax, they should make an election for federal withholding. We're going to talk about that as well. So we need to gather the appropriate information, and typically that can be gathered on a withdrawal form when you do that. So the steps really is that they contact you to request that distribution. You'll have them complete that withdrawal form and process the distribution. When you process that, you're going to more than likely give them a check paid to them, and the IRA owner then receives the money. You're then required to report that distribution on an IRS form 1099-R to the IRA owner so they can properly complete their income tax return, as well as the Internal Revenue Service. So the IRS is going to get the tax reporting as well to match up with their 1040. And then they'll document that distribution based on the information on that form 1099-R on their individual income tax return. So on page 40, we kind of walk you through those steps that you can see here on this slide for processing the distribution. Now, because distributions are subject to income tax or can be subject to income tax, you are required to provide them with the option to withhold income tax. So when we look at withholding and income tax, taxes are really pay as you go. What does that mean? Well, this means that you need to pay most of your tax during the year when you receive the income rather than paying it at the end of the year. And there's two ways to pay that income tax: through withholding from your pay, or when you take a distribution out of your retirement accounts, you can have withholding applied. Or some of these individuals that are retired may be making quarterly estimated tax payments during the year. So because of income tax generally being owed as the income is earned through this pay-as-you-go, financial organizations must notify the IRA owner and beneficiaries of their right to withhold federal withholding on IRA distributions. And that is going to be for any IRA distributions that in aggregate total $200 or more per year. So this provides the IRA owner or the beneficiary the opportunity to prepay that income tax. Now, that withholding notice has to be provided to the IRA owner based on how often they're taking their distributions. If they take distributions quarterly or more frequently, then you have to provide a withholding notice once a year prior to the first distribution, allowing them to make an election to have withholding apply and the amount, or maybe they want to waive out a withholding if they're paying quarterly estimated taxes. So based on this, we have to provide that notice. If they're taking distributions less frequently than quarterly, then you have to provide that distribution at the time they're taking the withdrawal. Or if they're taking maybe just annual distributions that they said, send me a distribution every December, that notice still has to be provided, but no more than 6 months in advance. So we have to provide them a distribution notice. Now, the withholding rate depends on if their distributions are payable on demand. In other words, they're considered non-periodic distributions, meaning they can vary or stop the payouts at any time. Most IRA distributions are non-periodic. If the payouts are not payable on demand, meaning they will receive a steady stream of payouts that cannot change. Maybe they've got an individual retirement annuity with an insurance company and they've annuitized distributions, then that distribution is deemed to be a periodic distribution. But for distributions at your bank, they're considered non-periodic distributions, and you are required to withhold at a rate of 10% unless they elect another different percentage. So how do we provide that? Well, we provide a withholding notice referred to as a W-4R, which allows the individual to withhold anywhere from 0 to 100% of the amount of the distribution. So we can withhold that. If they don't make an election, then the default rate is a 10% withholding that your bank should be withholding on that distribution. So a new form beginning this year that is going to be required, it replaces the old W-4P, is what's referred to as a W-4R. And the IRS released the new withholding January 4th of 2022. That's now been recently updated for 2023. Allowing them to make that election. So we must give them the opportunity to have withholding apply on that distribution. And it's required beginning January 1st of this year to use this W-4R for those non-periodic distributions. So it's important that we're providing that. Now, the default rate, if they don't make an election, is still 10% withholding. So that is going to be the amount. And another change this year is they have to specify the amount of withholding. So in the past, we used to be able to use a substitute W-4P where maybe they had a checkbox that said do not withhold. Well, the IRS wants to know that they truly elected no withholding. So instead of using the checkbox, if they elect to waive out a withholding, they actually have to place a 0 in that. So when we take a look at the withholding, now we have W-4P, which you can see on this slide that insurance companies will use if it's being paid out of an individual retirement annuity. But on the right-hand side, we're using the W-4R now. So when we take a look at that W-4R, if we take a look at the first top piece here, it says for non-periodic payments, the default withholding rate is 10%. You can choose to have a different rate between 0 and 100% and enter that on line 2. So when we do that, we're going to enter that on line 2 right here. So they can put anywhere from 0 to 100 in there to make that election. So they're able to make that election with the W4R by making that election on that W4R for that. So it gives them now the ability to make that election for that. I'm going to pull up a actual copy of that Form WR. Let's see here. See if I can get that to pull up so I can blow this up a little more for you. Okay, this is the 2022. Just want to let you know that this now has a new 2023 and has updated tables, but I wanted to pull the 22 one up so we can look at what this really is saying. So for non-periodic payments, the default withholding is 10%. You can choose to have a different rate by entering a rate between 0 and 100%. So to waive out a federal withholding here, they would actually have to type in a 0 and enter 0 there. Now, if you use a substitute W4R, you can use a substitute, but the IRS requires that all of the information on their W4R be provided, including these notes regarding that. Now, Debbie's going to talk about portability this afternoon and direct and indirect rollovers. The second bullet here is for eligible rollover distributions out of employer plans. If they don't directly roll that over, and she'll talk about that, those plans are required to withhold a default rate of 20%, which they cannot have less than that from their 401k plans, for instance. But IRAs can be anywhere from 0 to 10%. Now, what they've given is they've given the tax brackets based on their filing status here on the W4R. And if you use a substitute, that has to have all of that information in there so they can make appropriate withholding. So if someone's a single filer, for instance, and they earn more between 54,000 and 102, their withholding rate would be 22%. If they're not doing estimated taxes, they might want to put 22% federal withholding to apply on those distributions. So when we take a look at these distributions, we can use that W4R.
Hey, Jeff, before you go off
Okay.
of that, I just wanted to also point out in number 2, where you're typing in the percentage, it specifically states enter the rate as a whole number, no decimals. That's a question that I've gotten. It's the last sentence right before the series of dots.
Yeah.
That's a question that I've gotten frequently. So I just wanted to bring it up that it has to be a whole percentage. I know you said whole percentage, but I just wanted to have you highlight that.
Yeah.
And then there's a question in chat I want to make sure that you capture.
Yep. Is the W4R used by tax preparers or banks? Well, your bank should be using a W4R on these distributions now. So if you use a substitute form or maybe on your withdrawal statement, if you're using the Essentials withdrawal statement, we have updated our new withdrawal statements to include all of this information on that. So it gives them a place where they can write anywhere from 0 to 100% in there. And we also have all of the tax tables. So for 2023, this is the 2022, but there are new tax tables for 2023. So you should be doing that. I know some of you are using forms from Wolters Kluwer. Check your distribution form that they provide to make sure it has all of this information. Basically, our withdrawal statement has added 2 pages to it to have all of this information that's required by the IRS now for the withholding on these non-periodic distributions. I suspect Walters Kluwer has, but make sure you're up to date and make sure that these tables also are up to date as well for 2023. So the W4R is usually provided by those that are processing these distributions. So Kathy, I hope that's answered your question. Okay. So the W4R is a new one where we can provide that withholding rate from 0 to 100%. We can use that W4R to capture that, allowing them to prepay their income tax as well. Now, not only federal income tax, but some states also subject these withdrawals that are taxable to state income tax as well. So these that are shaded in, including your state of Michigan, have state withholding requirements where, in addition to the federal withholding, you're also required to withhold that. So in the back, and I'll pop that up here, in the back is, let's get over here and go back to a 29, we have withholding. And here in Michigan, any distribution from an IRA to an IRA owner or beneficiary born after December 31, 1945 is subject to 4.2% of the gross payment unless they complete that MIW4R. So Michigan's also updated their withholding statement as well. So all of you should be aware of this, where you not only have to give them the right to withhold federal, but for state withholding to pay those Michigan income taxes as well. So we show that as well. So Michigan is subject to that, but I just wanted to point out that all of those, that information is back in the job aid section as well, showing the state income tax rates and what is required. So Michigan, it's 4.25%. Any questions on withholding? Withholding is really just simply prepaying the income tax liability. Okay, now, because we can withdraw these at any time, but individual retirement arrangements are really intended to be used to provide retirement income. The tax laws and regulations really are designed to encourage them to leave those monies until they retire. But because they're still their own personal savings, distributions can be taken out prior to age 59.5. The IRS does assess a 10% additional tax on the amount that generally would be included in income. In other words, subject to income tax. And the taxable portion then is going to be subject to an additional tax of 10%. We call that the early distribution penalty tax. Your bank does not collect that. When they file their income taxes, that's when they're going to be paying that additional 10% penalty tax. So to discourage them from using that, they assess this additional 10% penalty tax. Now, the early distribution penalty tax, how do we know when they're subject to that? Well, if they're under age 59.5, what does that mean? Well, they haven't reached 6 months following their 59th birthday. So age 59.5 is exactly 6 months after their 59th birthday. And it's only going to apply to the taxable portion. So recall I said with traditional IRAs, we can take withdrawals out of a traditional IRA, but maybe we've made some non-deductible contributions. to that traditional IRA? Well, they have to track those non-deductible contributions by completing a tax form, IRS Form 8606, non-deductible IRA contribution form. Each year they make that non-deductible contribution, and that adds up their basis that they have. So later when they take withdrawals, that portion that they didn't get the tax deduction when withdrawn will not be subject to income tax. So when we look at the additional 10% penalty tax, if they've got some non-deductible contributions coming out, that portion is not subject to the 10% early distribution penalty tax. So it's up to them to track that. Now, if they're subject to the additional 10% penalty tax, or they may have to file IRS Form 5329, which is additional taxes on qualified plans, including IRAs and other tax favored accounts. If they owe that, the distribution code on the Form 1099-R will have a code 1 in box 7, which means that it's an early distribution with no known exception. And that tells the IRS and the IRA owner that they have to pay a 10% penalty tax on that taxable portion. So age 59.5 is our magic age for reaching retirement for IRA purposes. So let's take a look at an example. We've got Gary. He was born July 29th, 1963. So when did Gary attain age 59? When did he reach age 59? Chat that to me. When did Gary reach 59? Yeah, Gary reached age 59 on July 29th of 2022. So 6 months later is when he reached age 59.5. So when did Gary reach, or will he reach age 59.5? Yeah, very good. Later this month, he's going to reach 59.5, January 29th of 2023. So he's got about 11 more days until he no longer will be subject to that early distribution penalty tax. So right now he's still subject to that, but when he reaches 59.5, now they become normal distributions. Okay. Now let's take a look at page 44 of your guidebook. This lists all of the early distribution penalty tax exceptions. So age 59.5, we just talked about Gary, and when he reaches 59.5, once he does that 6 months after his 59th birthday, they become normal distributions. So for traditional IRAs, we'd use a code 7. If we have a distribution because the IRA owner died and we're paying it to the beneficiary, regardless of the age of the IRA owner or the beneficiary, they're not going to be subject to the early distribution penalty tax. So even if the beneficiary is much younger, they're never going to be subject to the early distribution penalty tax. Now, keep in mind, to process that, we want to make sure that we get a certified copy of the death certificate showing that the IRA owner is deceased. And for traditional IRAs, we would use a code 4. That's telling the IRS it's being paid to a beneficiary. Another one is disability. So if they're totally and permanently disabled and they provide proof to your bank that they are disabled, then you can use a code 3. Typically, they would be filing a Schedule R, which is a credit for the elderly or disabled, or they'd have to provide a physician statement. Then you can use a code 3 in box 7 of the 1099-R showing they meet that exception if they give you proof that they are totally and permanently disabled. If they don't, well, then just simply use a code 1. Code 1 for traditional IRAs means it's an early distribution with no known exception. they can still file that IRS Form 5329, additional taxes on qualified plans, including IRAs and other tax favored vehicles, to claim that exception if they don't give you proof. Another exception, IRS levies. The IRS is going to send you at your bank the levy to pay the IRA owner's income tax that they're owed to satisfy the lien that the IRS. Now, it's still a taxable distribution if it's coming out of a traditional IRA, but by golly, the IRS isn't going to assess the 10% early distribution penalty tax. I think if they have to go after the IRA assets, they're just glad to collect that income tax that has been owed to them. Another one is substantial equal periodic payments. Someone under 59 and a half can set up a series of distributions to provide a stream of income before they even reach age 59 and a half. They should be making a special election that they're doing this. And they then will get the same annual amount, and that must continue unchanged until the later of 5 years or until they reach age 59 and a half. And that can provide the stream of income. That 5-year requirement or 59 and a half, whichever is later, could be waived due to death or disability, but otherwise they cannot change the payment, and it's typically scheduled over their life expectancy or joint life expectancy of the IRA owner and their designated beneficiary. So they can set up that series of substantial equal periodic payments. These are sometimes called 72T payments, but all of these exceptions we're discussing come under that section of the tax code 72T. So for substantial equal periodic payments or IRS levy, the code on the 1099-R could be a code 2 because we have proof of that. Now, the ones after that, medical expenses, health insurance premiums, first-time home buyer expenses, higher education expenses for the IRA owner or their spouse or dependents, or qualified reservist distributions or qualified birth and adoption distributions. All of these are exceptions to the early distribution penalty tax, but your bank won't know if they truly use these. So you will always code these as a code 1 if it's from a traditional IRA, early distribution with no known exception. Why? Because you don't have the proof that they're meeting this exception. They'll have to file that form 5329 to claim the exception. So it's a tax form that they would have to file. Medical expenses have to exceed 7.5% of their adjusted gross income for that exception. If it's to pay for health insurance premiums following unemployment, they have to be unemployed for at least 12 consecutive weeks. Your bank won't have that evidence. They may be taking the home loan out at your bank, but you won't know if they've meet the home buyer ownership because they cannot have had ownership in a principal residence for 2 years, ending on the acquisition date. So first-time home buyer expenses, it can be up to $10,000 for that. And then qualified reservist distributions, if they're called to active duty for 180 days or more, they can take distributions out of their IRAs and salary deferral accounts such as a 401k plan and not be subject to the early distribution penalty tax. And then most recent is the qualified birth or adoption distribution that was issued under the Secure Act of 2019. That allows individuals to take up to $5,000 from their IRAs or other eligible retirement accounts for each qualified birth or adoption event. So in the case of twins, they could potentially take out $5,000 for each one. So for a total of 10,000. So it allows them to take that. Now, interestingly enough, these qualified birth or adoptions under Secure are also were permitted to be repaid, and there was no timeline. Well, Congress corrected that, and now with other repayments, they have 3 years from when they take that distribution to repay that back. So that's something that came up under that newest piece of legislation that was just passed, Secure 2.0, which was passed at the end of December. So as you can see, we've got a lot of different exceptions to the early distribution penalty tax that could be used as well. Now, we're also going to be talking about Roth distributions. These early distribution penalty tax distributions apply to Roth distributions as well. And if it's a non-qualified distribution, we'll use a code J for those. But we also have a number of events for qualifying reasons for qualified distributions for Roths, 59.5, death, disability, and our fourth one, first-time home buyer expenses, can be the qualifying event for qualified distributions where they're all tax-free. So we'll talk about what's required for that in just a little while here. Any questions on the early distribution penalty tax? Again, that's not a tax that you'll collect. That's an additional tax that they will pay when they file their income taxes, unless they meet one of these exceptions. Any questions? Okay. So on page 45, we've got some questions here. Let's work through these together. We'll give you a chance to chat your answers in. We've got Maggie. She's age 65, and she's going to withdraw $10,000 from her IRA to cover her expenses for a trip to the Galapagos Islands. Wow, that sounds like quite a trip. I'd like to go with Maggie on that trip. The Galapagos Islands, if you have not heard of those, are a number of islands that are off the coast of Ecuador in the Pacific, where there's a lot of rare bird and animal species that can only be found there. So that'd be quite an exciting trip. So our first question is, if Maggie elects federal withholding, can she withhold 8% using the W-4R? What do you think? Chat that answer to me. Can Maggie withhold 8%? Chat your answer in. Can she withhold 8% on the W-4R? I see some yeses coming in, and you're absolutely correct. That is a change from the old W-4P or the substitute, where it was 10% or more. Now Maggie can elect anywhere from 0 to 25 or to 100% for federal withholding. Now, if Maggie doesn't make an election, what is the rate that will be withheld for federal income tax purposes by your bank? What would you withhold if she did not make an election? Very good. Yes. Kathy, Veronica, Amy, it is 10%. You are absolutely right. Okay. Let's take a look at Catherine. Catherine wants to withdraw $15,000 from her traditional IRA to buy a car. Catherine will be 59.5 next week. Is Catherine subject to the 10% early distribution penalty tax? What do you think? Why or why not? Yes, she's not 59.5 yet, So at the time of the distribution and does not have an exception. So what should she do? What should she do? Wait till next week, right? Wait a week. Exactly. That would be the best thing. Cars aren't very cheap. They're pretty expensive. So that'd be the best thing. So what portion of the distribution is subject to the early distribution penalty tax? The taxable, the non-taxable, or both? Which portion is subject to the early distribution penalty tax? Chat those answers in. Which portion? Taxable, non-taxable, or both? Yes, the taxable portion is what it is. So if she's got some non-taxable assets that she's withdrawing, that would not be subject to that. So should your bank collect the early distribution penalty tax? Do you collect that early distribution penalty tax? Yes or no? No, you don't. That is an additional tax that Catherine will have to pay when she files her income taxes. So it's not something that you would collect. Now, inadvertently, if Catherine elects more federal withholding, for instance, she may have enough withholding to cover that additional 10% tax. So that might be possible. Okay, now we've got a number of exceptions here. Which of the following are exceptions to the 10% early distribution penalty tax that Catherine could possibly use if she's qualified? Which ones? And go ahead and abbreviate if you want to. You can simply just use even the first letter if you want. Higher education, yes, that is. Disability, and first-time home buyer expenses. So vacation isn't going to work, landscaping, or the addition to her house. Okay, very good. Any questions on the early distribution penalty tax? Any questions? Okay. So the early distribution penalty tax and those exceptions do apply to both traditional IRA and Roth IRAs. Let's talk about traditional IRA distributions and the taxation on those. So when we withdraw from traditional IRAs, the contributions that are deductible and any earnings that have grown in that traditional IRA will be subject to income tax in the year that they are withdrawn. So the withdrawal of any earnings in a traditional that are attributable to non-deductible contributions also are subject to income tax. So all the deductible contributions and earnings are going to be subject to income tax. What is not subject to income tax is going to be any non-deductible contributions. So when they make those non-deductible contributions, this creates basis in the IRA. And the IRA owner should use IRS Form 8606 to determine that taxable and non-taxable portion when they have a withdrawal. So when we look at that, it's only going to be the deductible and non-deductible contributions get all lumped together, and the earnings when they take a withdrawal. So they can't just say, hey, I'm going to set up my own separate IRA to hold non-deductible contributions, and then I'll have my deductible contributions in another IRA. The IRS says if you have IRAs, all your traditional IRAs, simple IRAs, and SEP contributions in traditional IRAs will all get lumped together for determining the taxation. So let's say we have, this is our IRA and it's got all deductible contributions in it. Okay. Now we're going to make a non-deductible contribution into the IRA. Here goes our non-deductible. Okay, that was the Coke going in there. Can I withdraw just the non-deductible contributions out of there? Or do I have to take some of the non-deductible, some of the deductible, as well as earnings? What do you think? Do you think I have to take a little bit of each? Well, let's take a distribution and see. Yeah, I got some of that non-deductible along with all the deductible and the earnings as well. So we just can't separate that out when we're doing our withdrawals. So that's what Form 8606 does. So if we take a look at Eddie as an example there on page 46, he's withdrawing $1,000 from his traditional IRA, which contains $9,000 of regular contributions. Out of those regular contributions that Eddie made, he's got 8,000 deductible contributions and $1,000 non-deductible contributions, totaling the 9,000. He's also got 1,000 in earnings. So when he withdraws that 1,000, we're going to take some of each of these out when we take the withdrawal. So he's going to sit down with his tax advisor and calculate the pro rata basis when he files his tax return. And that's the purpose of IRS Form 8606. So when he does that, he's going to withdraw that. So really what 8606 does is it takes the basis, that's the 1,000 non-deductible, divides that by the overall IRA balance, 10,000 or 9,000 and earnings. And that means the pro rata amount excluded from income will be 10% or $900 will be subject to tax, and $100, the 10% would be excluded from income. So that's what Form 8606 is going to do, is tell Eddie how to report that on his tax return. Nothing you have to worry at your bank. It's all up to Eddie. Questions on that? So again, we can have basis that does that. Any questions? All right. Now, traditional IRAs are also subject to required minimum distributions. So once they reach age 72, the Secure Act increased the age of 70 and a half to age 72, beginning in 2020 and later years. So anyone that reached age, that was born on or after July 1st, 1949, their new age for RMDs was age 72. Now, another change that's taken place here has been the Secure 2.0 that was just passed, has increased that age. Now beginning in 2023, instead of 72 is now age 73. So that's not reflected in your guidebook. You might want to just jot down in the corner, beginning in 2023, the RMD age is now going to be age 73. So once they reach RMD age, they have to begin taking required minimum distributions out each year. And that begins in the year beginning for those born after July 1st, 1949, when they reach age 72. Now, our guidebook has not been updated quite yet. So this is still reflecting age 72 here. So if someone was born in 1951, we would add 72 to their birth year. And that tells them that they would have to begin taking distributions in 2023. Now, that is going to be their first distribution year. So let's just change this. This will be age 73. The deadline to remove the first one, once they reach RMD age, is called their required beginning date, or RBD. That's April 1st, following the year in which they attain RMD age. Again, that's increased to age 73. So beginning next year, everyone will be 73. So if someone turns 72 this year, which our examples reflect, they normally would have had an RMD due in 2023. The required beginning date then is April 1st of 2024, and then they have to take distributions by 12/31 of each year. So 12/31 of 2024. So if we have someone born in 1952, when do they reach age 72? Well, it'd be 2024, but now it's age 73. So really this should be 2025. Their required beginning date, we'd add one, would be April 1st of the next year. And then all subsequent RMDs need to be distributed by December 31st of each year. Any questions on RMDs? Again, this will get updated, but that law got passed so recently, the end of the last week in December there, that we now have a new age. Any questions on age 73? One thing I want to point out about age 73 for those beginning in 2023, that becomes the new age. That is going to be increased to age 75 in the year of 2033. So 10 years from now, our age 73 is going to increase to age 75. So something Congress is looking at, that people are living longer, they should be able to start their required minimum distributions at a later date. Okay. Now, if they don't take a distribution, if they fail to withdraw their RMD, they're subject to a 50% excess accumulation penalty tax on the amount that they should have distributed, but they have not. So if they had a RMD of $13,000 or $12,000, for instance, and let's say it's $13,000, and they've been taking monthly distributions of $1,000, so they take a total of $12,000 each month. And then in December they come and take the last $1,000 to satisfy their RMD. Well, if they got missed that last one, the $1,000 they didn't distributed is the portion that would be subject to the 50% penalty tax, not the full amount. Now, they pay that 50% penalty tax on Form 5329, but if they have reasonable cause, they can request that penalty tax be waived by the IRS. Another thing to note on that 50% penalty tax that's now being decreased to 25% under Secure 2.0. So again, the IRS is not going to assess such a large penalty on these missed RMDs. So they're giving a little relief now with Congress lowering that penalty for RMDs that have been missed. Now, usually individuals can request a waiver of that, filing Form 5329, but to qualify for the waiver, they have to make up that missed RMD as well. Questions on the 50% penalty tax? Okay. Now, once they reach RMD age, your bank is required to send out an RMD statement to the IRA owner that has a traditional IRA or maybe simple IRA once they reach RMD age. That RMD statement has to indicate the amount of the RMD, or if it does not, you have to extend an offer to calculate the RMD. It gets sent out by January 31st of each year. So sometimes it might be provided on the year-end statement, the fair market value statement that you send out indicating that they have to take an RMD. So that RMD statement should include either the amount or an offer to calculate it. It should also include the deadline for which the RMD needs to be distributed. So if it's their first RMD, it should indicate it's the required beginning date, April 1st, following attaining RMD age. And then each subsequent year, it'd be 12/31. So it should indicate that on there. Also, it should have an indication that the IRS is going to be informed that they have to take an RMD. So it can be really in any written format as long as it's sent to them by January 31st. At your bank, do you calculate the RMD in your RMD statement, or do you offer to calculate it? Does it include the amount? Chat that to me. The amount or offer to calculate. Or if you don't do tax reporting, you can put, I don't know. I always like to do a little poll to see what. A lot of banks that I see do offer the amount. It's just good customer service, and it assists their customers with that as well. Okay. Questions on RMDs, required minimum distributions. Questions on RMDs. Okay. Now let's talk about Roth distributions. Now, the reason why anyone wants a Roth distribution is for these qualified distributions. The tax treatment depends on whether the distribution is considered qualified or non-qualified. For qualified, we have to meet a 5-year waiting period and have a qualified reason. So if we meet both, so it's 5 years and the qualified reason, then it's a qualified distribution and it's all tax-free and penalty-free, including all of the earnings that are distributed. So with Roth IRAs, we look at it and it'll be qualified. If it's a non-qualified distribution, it could be subject to tax and penalty. So we have to meet 5-year period and have a qualified reason. So let's look at that 5-year period for qualified distributions. The 5-year period begins January 1st of the year that they first fund any Roth IRA. So it's the taxpayer only really has one 5-year period for determining Roth contributions, or Roth qualified distributions, I should say. Even if they have more than one Roth IRA, each Roth IRA does not start a new 5-year period. That 5-year period begins January 1st of the earliest year in which they made their first Roth contribution. The way we can fund that Roth contribution is by making a regular contribution or maybe doing a conversion. A conversion is a taxable movement out of a traditional IRA that gets converted and contributed into a Roth IRA. So if they fund their Roth IRA with a conversion, another way to do it is maybe roll over from an employer plan into a Roth IRA. Debbie will talk more about direct and indirect rollovers from employer plans when we talk about portability. But that would be one another way that we could do that. So it begins January 1st. So recall Debbie talked about those prior year contributions, the carryback contributions, where we have till our tax deadline to fund our IRA for the prior year. So if someone makes a prior year contribution today on January 18th for 2022, it doesn't begin January 1st of this year. We actually get to use the year that it's funded for. So if it was funded today for last year, and that's the first Roth contribution they make, their 5-year period begins January 1st of 2022. So once 5 years has passed, then we look to see, do we have a qualifying event? So we look at what year is it funded for. Now, after we've satisfied the 5-year period, then we need a qualified reason, 59.5, disability, death, or first-time home purchase. Any of those qualified reasons and 5 years make it a qualified distribution. So we know our retirement age, 59.5, is reached. If we've had it 5 years, it's all tax-free and penalty-free. If it's due to death or disability, or maybe they're using it as first-time home buyer expenses, they could take up to $10,000 as a qualified distribution, which could include the earnings, and that would then all be tax-free as well. So qualified distributions are always tax-free. So let's take a look at our 5-year period. We got Theo here. He opened his Roth IRA with a regular Roth IRA contribution on April 29th or April 12th of 2019, and he made it for the prior year, 2018. So when does Theo's 5-year period begin? Chat that in the chat. When did his 5-year period begin? Yeah, January 1st of 2018. So we get to use what year was it funded for. So what date did he meet the 5-year period? When did he meet his 5-year period? On what date? January 1st of 2023 is when he's met his 5-year period. So we're past that. We're at July 18th of 2023. I can't quite tell how old Theo is. He might be 59.5 if he is. They're qualified distributions and would all be tax-free. If he's not yet, I'm not sure that he's disabled, or he's certainly still smiling, so death isn't his qualified reason. But if he's using it as first-time home buyer because he hasn't owned a home in the previous 2 years, it could be a qualified distribution. Now, if Theo doesn't meet both of those, it's considered a non-qualified distribution. So a Roth distribution that does not meet both is considered a non-qualified distribution out of that IRA. And when we look at our non-qualified distributions, we have to meet them both. And if we don't meet both, then we have ordering rules, which determines is it subject to tax and penalty. So if you take a look at page 50, we have our ordering rules. Our slide's going to make it look like a cake. So if you think about it, we start at the top and work our way down, okay? The top of it is our regular contributions, which include our spousal contributions, any catch-up contributions. So those annual contributions that Debbie talked about earlier get distributed first. And because there's no deduction on any Roth regular catch-up or spousal contributions, because that creates basis in the Roth IRA and they're distributed first, they come out income tax free and penalty free. So they're always tax and penalty free. So that's what makes Roth IRAs very attractive also, is because you can always access that basis and there's no tax liability when you withdraw your regular contributions first. Now, after those have been totally withdrawn, then we go to the second layer of the cake, or in the middle there on page 50. And what comes out next are any conversion dollars and retirement plan rollovers. And they're going to be distributed after we totally deplete all the regular contributions. Now, because they pay income tax in the year of the conversion or the year that they roll it over, those come out income tax free. So they're not going to be subject to any income tax. And we take the oldest monies out first. Now, if they happen to be under age 59 and a half, this bucket of money in the Roth IRA can be subject to the early distribution penalty tax if they have not left it in 4 or 5 years. So the early distribution penalty tax may apply. I like to call it the recapture tax. The IRS recaptures that early distribution penalty if they've pulled it out. They won't pay income tax, but they could be subject to the early distribution penalty tax. Then after all the regular contributions get depleted first, then second, the conversion and rollovers, then we get in the bottom, and the earnings will always be subject to income tax, and if under 59 and a half, the additional 10% penalty tax. Now, to determine that, IRS Form 8606 is the tax form that the Roth IRA owner will complete. Recall that IRS Form 8606 is non-deductible IRA contribution. So that gets completed by the Roth IRA owner to determine the taxation on that. Any questions on the ordering rules? Any questions on the ordering rules? Okay, let's take a look at Daniel. Daniel's going to withdraw $1,000 from his Roth IRA today to make a mortgage payment. He opened his Roth IRA with a regular contribution November 16th, 2011. So does Daniel have a qualified distribution or a non-qualified distribution? What do you think? Chat that in to me. Which one? Qualified or non-qualified? He's 36 and he's going to withdraw $1,000 from his Roth. Yeah, it's non-qualified distribution. Why? He has satisfied his 5-year period from 2011. So that began January 1 of 2011. And so he satisfied that 5 years later, but he's only age 36. Mortgage payment is not a qualified reason. That's not first time home. That's just paying your mortgage. So that would not be a qualified reason. So he's got non-qualified distribution. Now he's only taking out $1,000, and we don't know since 2011 how much he's actually put in regular contributions. It could be tax-free if it's just his basis, the annual regular contributions coming out, which could have no tax consequence. But again, he'll have to file Form 8606 to determine the taxation on that distribution. Okay. On page 51, we've got some questions here. Let's pull that up. I'll give you a moment to read through those questions and answer that, and then we're going to go through these together and answer those questions and see how well you did. So I'll give you just a minute or so to read through those so you can jot down in your guidebook what you think those answers are. Then we'll go through those together and give you the opportunity to chat your answers. Okay, let's take a look at these. IRA distribution questions on page 51. So which IRS form will be used to determine the taxable portion of an IRA distribution? And who's responsible for completing that? Which form are we going to use? Veronica, very good. So the tax form to report the taxable portion of an IRA distribution is going to be IRS form 8606. So IRS form 8606 is the tax form. And it's up to the IRA owner to complete that. That's nothing you have to worry at your bank. Okay, question 2. When non-qualified Roth IRA assets are distributed, which type of assets are subject to the early distribution penalty tax? Regular contributions, conversion, retirement plan rollovers, or earnings? Or do we have a combination? Chat that in. What do you think? Which could be subject to the early distribution penalty tax? Yeah, our conversion and retirement plan rollovers and the earnings. Those are what could be. Our regular contributions are always going to be tax-free, and because they're tax-free, there's no early distribution penalty tax. Okay, number 3. When non-qualified Roth assets are distributed, which type of assets are subject to income taxes? So when non-qualified Roth assets are distributed, what are subject to income tax? Yeah, if we look at our ordering rules there on page 50, it's just the earnings. And then when traditional, number 4, when traditional IRA assets are distributed, which types of assets are subject to income taxes and the early distribution penalty tax? Yeah, our deductible contributions and the earnings. Very good. Questions on Roth distributions? Questions on Roth distribution? Okay, now when we process withdrawals, it's good to use a withdrawal authorization form. This is a copy of the Essentials withdrawal authorization form that could be used for traditional IRAs. We're going to get the amount of the withdrawal and the date, What is the reason? It's a normal, they're over 59.5 or early under, so we're going to capture that. Note that we have a withholding election. This has been updated now for the W4R. It says that the default rate is 10%. You can choose a rate anywhere from 0 to 100, and they'd have to write that. Recall Debbie had mentioned earlier, and we said that it has to be a whole number, no decimals there. So that can be written in there. This is just showing the actual rate, but this is a good way to capture that. If you don't use the census forms, review your own withdrawal authorization form to ensure it has all that information. Now, we also report these distributions on IRS Form 1099-R, distributions from pensions, annuities, retirement or profit sharing plans, IRAs, insurance contracts, etc. That Form 1099-R has to be sent to the recipient by January 31st of each year so they can complete their income tax return, the Form 1040. The IRS gets a copy of this electronically by March 31st. If you happen to just have a few of these and file by paper, then February 28th would be the deadline to remit this to the IRS. The IRS is then going to match that up with their distribution reporting on their form. So for a 1099-R, we're going to put the gross amount in box 1, the total amount being withdrawn. We're going to mark in 2A, the taxable amount will be the same as the amount in box 1. So we're going to leave that. If it's a Roth IRA, we'll leave that blank. We're going to mark taxable amount not determined. And if they close the IRA, we will mark that it's a total distribution as well. And then we're going to then also, if they have federal withholding apply, put that in box 4. And then our distribution codes are going to be reported in box 7. And if it's out of a traditional SEP or simple, we check that. We do not check it if it's a Roth distribution. For our traditional IRA codes in box 7, if it's an early distribution with no known exception, we'll use a code 1. If it's an IRS levy, or they've set up a substantially equal periodic payments and they're under 59.5, or maybe a direct conversion from a traditional IRA, we'll use a code 2, which means it's an early distribution with a known exception. If they gave you proof such as a Schedule R because they're disabled, we can use code 3. If it's a death distribution paid to a beneficiary that provided that certified copy of the death certificate, code 4. And then our normal distributions for all those traditional IRA owners over age 59.5, code 7 for normal distribution. For Roths, the IRS says to use alpha codes. We use code J for our early distribution and non-qualified distributions. If it's an IRS levy from a Roth IRA, it's still simply a code 2. And then if we know one of our 3 qualified reasons, 59.5, death to a beneficiary, or disability, they gave us proof, we can use a code T. If we don't know the 5-year period has been met, if we know one of those apply and the 5-year rule, we'll use code Q. So those are the alpha codes that we use for our distributions. Any questions on the tax reporting on distributions? Okay, let's do our running review here of what we covered in distributions. We're going to move our little guy over to distributions. And what 2 taxes could our distributions be subject to? Well, income tax, where it's treated as ordinary income, or if under 59.5, the early distribution penalty tax. For traditional IRAs, once they reach age 72, which is now going to be age 73, beginning in 2023, that's the year they have to start taking required minimum distributions. We do not have RMDs from traditional or from Roth IRAs, only traditional IRA SEP and simples. For tax reporting, we send the 1099-R to the IRA owner by January 31st. If you file paper with the IRS, they get it by February 28th, and then most of you would be filing electronically. So that's distributions. Any questions on distributions? Okay. Next, we have portability. Debbie, shall we take a short break? What do you think?
Yeah, I think we have time. We have 10 minutes and I can still finish up by 3 o'clock their time.
Okay, wonderful.
I think I got my clock to work too. So we'll see you in 10 minutes.
Yeah, if you click on that and then the little arrows up there.
Oh, it just was working on the other screen.
Click that. There you go. Click that.
This one?
Yeah. Now hit it.
Oh,
Oh,
working
still
on
doesn't want to do that.
Okay. See you in 10.
See you in 10.
Okay, well, welcome back. We are going to finish up our day with our section on portability. And we are going to be on our learning objectives on page 57. So let's go ahead and start with that. And I don't see any questions that came in over the break on chat, but if you do have anything that has come up from anything that Jeff and I talked about or didn't talk about already today, please feel free to just unmute your phones or send that through chat and we'll take a look at those as we get them. So with that, on page 57, after this section, we want to be able to differentiate between two different types of movements of money between IRAs, which are called transfers and rollovers, as well as two different types of movement between what's called between employer plans and IRAs, what's called a direct rollover and an indirect rollover. When we're looking at these types of transactions, they're going to look and feel very similar to each other, but they all have different nuances that keep those four different transaction types apart and different characteristics that we're going to take a look at. So the first thing that we're going to focus on is our movement between IRA to IRA. And there's 3 diagrams on page 58 of your guidebook. I've condensed them into one on the screen as far as IRA to IRA portability. So when you're moving from a traditional to a traditional IRA, or a Roth to a Roth IRA, or a simple IRA to a simple IRA, you can move that through 2 different methods, through a transfer, which you can see the arrow goes directly across, and you can also move those assets in what's called a rollover transaction. And that's where you're going to see from this diagram, there's an actual distribution that the owner then receives, and then they are going to then be responsible for completing the second step of that transaction, which is the actual rollover contribution. So this is going to be a standard distribution. There's no such thing as a rollover distribution. It's just a standard distribution like Jeff talked about. And it becomes a rollover contribution if they meet the rules and they go ahead and put that in to that same or similar IRA type. We'll see that from our characteristics screen. Now, the note on the bottom of page 58, I want to point out that with this type of movement, a transfer or a rollover between IRAs of the same or similar type, there's no age requirement, there's no eligible compensation requirement, and there's no dollar limitation. So my dad can move any amount of money that he wants from his traditional IRA to another traditional IRA, new or existing. It doesn't matter that he's 80. It doesn't matter that he technically is fully retired and has no eligible compensation. And it doesn't matter how much he moves, whether he moves $1, whether he moves $10,000, $100,000, it doesn't matter. There's no limitations on that, because all we're doing here in a transfer or a rollover is repositioning or reallocating where those assets are being held. So we're just moving those existing assets. There's no new money coming in like we talked about in funding. Now, when we're talking about those 2 transactions, transfer versus rollover, they accomplish the same thing, moving money from one IRA to another IRA of the same or similar type. But there's differences within the characteristics that make them a transfer or a rollover depending. So we're going to take a look at the transfer characteristics first, and those are on page 59. So generally speaking, as I said, it occurs between the same type of IRA, which is a traditional to traditional, Roth to Roth, simple to simple. However, you can move assets from a traditional to a simple or vice versa if the simple IRA owner has met the 2-year clock on that simple IRA. So they are in charge of making sure that they have met that 2-year waiting period on the simple before it is distributed to a traditional IRA or it receives traditional IRA assets, but it can be done. In a transfer, there's no constructive receipt of the assets. So the check is going to be payable if you're the distributing side. From your organization, the check will be payable to the other financial organization, for example, ABC Financial Organization, for benefit of Deborah Shipman. Because it's not payable to Deborah Shipman, it's payable to ABC Financial, I don't actually have constructive receipt of the assets. even if you give me the check in my physical possession to then take over to ABC Financial, I still can't cash that check because it's not payable to me. So that's no constructive receipt of assets. It's clear from the check who it's titled to, who it's payable to, the other financial organization in this case, for benefit of, or FBO, maybe an abbreviation due to character restrictions, for my benefit. So it's for my IRA, for the benefit of me. But again, no constructive receipt of assets. Because I don't have access to the money, there's an unlimited number of times that I can complete a transfer. So the IRS does not have any set limitation on how long the assets can be in my possession, or how, if, and I say my possession loosely, how long I hold that check that's payable to the other financial organization, or how long it takes if you mail it over to ABC Financial. It doesn't have a time restriction on that. It also doesn't have a restriction on the number of times in which I can complete a transfer. So I could do a transfer every other day if I wanted to. And the IRS has no problem with that because, again, the checks are payable to the other financial organization for benefit of Deborah Shipman. Now, if you're on the receiving side of that, the check would be payable to your financial organization for benefit of Deborah Shipman. And then you would go ahead and deposit that as a transfer if it's coming from another IRA. Because I don't have constructive receipt of the assets, there's no true distribution. And so the withholding rules that Jeff talked about in our distribution section are not going to apply. So it's an automatic no withholding scenario. The money that I request to have distributed as a transfer is going to then be wholly transferred. So if I would like to have $10,000 moved as a transfer from IRA A to IRA B at the other financial organization, it would be for a full $10,000. There would be no withholding since, again, I'm not receiving any money. There's no potential tax liability on my end. It's very clean because there's no constructive receipt of assets. Therefore, there's no reporting. So the 1099-R that Jeff talked about in our distribution section, where you have to report what the distribution was to the IRS and to the owner by January 31st or February 28th or March 31st, depending, that doesn't occur. So there's no 1099-R reporting from the financial that is sending the assets out. And there's no corresponding 5490 information for the financial organization that's receiving the assets as a transfer. The owner also does not have to report that on their tax return. So it's a very clean way to move assets from one IRA to another IRA of the same or similar type. Now, the transfer characteristics are over on page 60, and you'll see that that chart on page 60 is longer than the chart that we saw with the transfer characteristics on page 59. And that's because now the owner is going to actually receive the money. So we have some more rules in play. So the first one is the same. The movement of money is always going to be between like IRAs. So again, traditional to traditional, Roth to Roth, simple to simple, or if the simple IRA owner has met the 2-year waiting period on that simple IRA, they then can move between the traditional and the simple. In this case, I actually, as the owner of the IRA, have constructive receipt of the assets. So this again is a true distribution to me. I'm receiving a check payable to Deborah Shipman. I'm receiving money that was moved into, distributed from my IRA into my savings account, my checking account, my non-IRA account. I'm receiving cash. Somewhere along the lines, I'm getting access to that money. Because I now have access to that money through constructive receipt, the IRS does impose time limitations on these types of movements. First of all, when I have possession of the assets, whether it's a check payable to me, movement into my non-IRA account or cash, I now have only 60 days that I can have the money in my possession. If I receive the money today on January 18th, tomorrow, January 19th, is going to be day one. So the day always starts for the 60-day rule with the day after the owner has received the assets. So when I'm counting out my 60 days, if I receive the assets today, tomorrow is going to be day one. When I'm counting out my 60 days, I do count Saturdays and Sundays as well. There's nothing in the tax laws, however, that says if I land on a Saturday, Sunday, or legal holiday, that I should move to the next business day. Therefore, conservatively, you would move backwards. For the IRA owner would move backwards. So if I land on a Sunday and it's non-business day, I would move to the business day prior. The IRS also imposes a time limit on how often I can do a distribution and a subsequent rollover of those assets. And that's once per 12 months. That's not once in a calendar year. It's once in a 365-day period. So again, if I do a distribution today and I roll it over within the next 60 days, I can only do another distribution and roll those assets over a year from January 18th, 2023, a year from the first distribution that I did and rolled over. So this prohibits me from doing rollovers and having access to that money more than once in a 365-day period. So if I do that distribution today, let's say I just roll it over tomorrow, I do it really quickly, then 2 months down the road, I decide that I want to move additional assets from even a different IRA. The IRS says that 1 per 12-month rule is per taxpayer, not per IRA. So I can only do a transfer for the next 365 days. I cannot do another distribution that I intend to roll over. I can certainly do a distribution and keep the assets. But as Jeff said, when I do a distribution, it is going to be reportable and subject to income taxes. Since I can't roll over that second distribution, I would be subject to income taxes and penalties accordingly. So if I want to move the assets in that 365-day time frame, once I've already done one distribution and rollover, then I'm going to have to do a transfer. Because this is just a distribution to the IRA owner, and the financial organization has no guarantee that I'm actually going to roll those assets over, even though I tell them that's what my intent is, we have to treat it from the distributing financial organization side as a standard distribution. And therefore, we have to follow the withholding rules that Jeff talked about in our distribution section. So we have to offer the withholding. They make an election. Remember, they can choose on a W4R or an acceptable substitute to choose any percentage between 0 and 100%. 0 is obviously waive, 1% or greater in whole numbers, no decimals, if they want to do the withholding. However, if they do not make an election, we do have to mandatorily withhold 10%. If the intent of the owner is to roll over the assets and not keep anything, they likely will choose to waive the withholding, but we do have to offer it. Now, my dad, remember, is 80, and so he does have an RMD, or required minimum distribution, that he does have to take out every year. Whether he does that every month, whether he does it every couple of months, or once a year, there's an amount annually that has to come out. That amount cannot be rolled over. So if my dad has a $100,000 balance in his traditional IRA and he has an RMD of $2,000, he can only roll over $98,000. He's not eligible to roll over the other $2,000. He has to receive that, keep that, because that represents his RMD amount. So no RMD is allowed to be rolled over for owners who are in their RMD period and have an RMD for that particular year. When I am documenting that rollover contribution, I, as the IRA owner, have to irrevocably designate that transaction as a rollover. You'll want to check your vendor forms, because I don't know how all vendor forms read, but a census form that we're going to take a look at a little bit later does have language on there that says I irrevocably designate this transaction as a rollover. And then, of course, the owner would sign the form, and that would then give you the irrevocable rollover designation. Because the owner has access to the money, this is a reportable transaction, both the distribution and the subsequent rollover contribution. So the distributing financial organization is going to give me the money in some form or fashion, a check payable to me, moving it into my checking or savings account, giving me cash, and then they will also create a 1099-R, like Jeff talked, and send that to me by January 31st of the year after the distribution. They will also send that information to the IRS either by February 28th or March 31st, depending on their reporting method. Once I roll those assets over within 60 days, assuming I am allowed to do that, I haven't violated the 1 per 12-month rule, the receiving financial organization will then subsequently report the receipt of those assets as a rollover on IRS Form 5498. And we're going to take a look at that 5498 again. We looked at it in funding, but we only looked at it from a reporting of regular contribution perspective. So this time in this section, at the end, we will look at our reporting of a rollover contribution. IRA rollover, direct rollover, indirect rollover, the 3 rollover transactions of the 4 that we're going to be talking about today. Remember the transfer, which is the IRA to IRA with no constructive receipt of assets, that is non-reportable, so there's no tax reporting for the financial or for the client. Since the owner is receiving a 1099-R and a subsequent 5498 for the completion of that rollover contribution, they will also have to report that on their tax return when they file their return for that particular year. That is done outside of the financial organization, but it is important to understand that not only does the financial organization distributing and or receiving have to do reporting to the IRS and to the IRA owner, but the owner also has a responsibility to report that rollover on their tax return as well. Questions at all on that before we take a look at an activity to compare the two, transfers versus rollovers? Okay, so we are on page 61, and what we are going to do is just mark which type of transaction, transfer, rollover, or neither applies to the provision. And please feel free to use chat. You can certainly abbreviate T, R, or N as far as which provision or which type of transaction that provision applies to. So in the first one, we have withholding rules do not apply. Does that apply to a transfer, a rollover, or neither? Thank you. So it's actually just going to be one of them. Remember whoops, I clicked one too many times there again. In the rollover, this is a distribution to the owner, and therefore we have to offer the withholding. On a transfer, it's 100% going over to the other financial organization, check payable to the other financial organization, and therefore it's an automatic do not withhold, so withholding rules do not apply in that scenario. Which one of these transfer, rollover, neither, is there an age requirement? You have to be a certain age in which to do that. You can't be over a certain age to still do that. Thank you. And that is neither. If you didn't peek at my early click, neither of them have an age requirement. So I can do it at 50. My dad can do it at 80. My son recently opened up a Roth IRA. And while he is a minor, I had to sign on his behalf, but he can technically do it. I would have to authorize it at this particular juncture because of guardianship. But let's say he's 18, he can do it. There's no age requirement there. Which one of these, transfer, rollover, neither, has no constructive receipt of the assets? Check payable to the other financial organization. Perfect. And that is in fact our transfer. Which one of these requires an irrevocable designation? The client has to irrevocably designate this transaction as such. Perfect. That is our rollover. Which one of these has a 60-day rule attached to it? You can only have the money for 60 days. Perfect. That is our rollover. And remember, our 60 days is always the day after the owner has received the money. If they have questions on counting out that 60 days, day one is always the day after they receive the assets. Which one has no reporting? There's no 1099-R, there's no 5498. So the financial organization doesn't have to report it, and neither does the client. Perfect. Thank you. That is in fact our transfer. Which one has an eligible compensation requirement? You have to have eligible compensation in which to do this type of transaction. Thank you. And that is in fact neither. Whoa, one too many. I get a little clicky. My dad is 80. My dad is technically fully retired, so he has no wages, salaries, tips, bonuses, commissions, professional fees, etc. He can still do a transfer. He could still do a rollover as long as he meets the rules in which to do those characteristics that we talked about back on 59 and 60. So he can do that even though he has no eligible compensation requirement. My brother, Matt, who is a stay-at-home dad with no eligible compensation on his own, Melissa is out of the picture, okay? Just looking at Matt, he can do this because there's no eligible compensation requirement. I'm working, I have eligible compensation. It's irrelevant. I can do either one of these transactions. Again, I have to meet the characteristics for the type of transaction that I'm choosing, but I do not have to have eligible compensation in which to do that. Which one of these can I do an unlimited number of times? There's no time limits associated at all with this type of movement. Thank you. That is the transfer. And which one of these has a 1 per 12-month rule associated with it? You can only do this once every 365 days from date of distribution. And that is, in fact, thank you, our rollover. Excuse me. So page 61, just a little bit about those characteristics that we talked about on page 59 and 60, going back and forth as to which ones apply to either type, because they very much feel similar as far as the goal is to move money from A to B, but the way in which it's moved is different. The time frames as far as how often you can do that, limitations and so forth is different, requirements and so forth for designation, that's different. So there's little nuances that make them a little bit different from each other. Now, the next thing that we want to take a look at on page 62 is movement between employer plans and IRAs. So we talked about the transfer and the rollover, which is IRA to IRA. Now we're going to shift gears a little bit and say the money is coming from an employer plan, and now it's coming into our financial organization as a holder of the traditional, the simple, or the Roth IRA. We have two different types of movements. Again, we have a direct rollover, which goes kind of directly across from the plan to the IRA. And we have an indirect rollover where you can see there is a distribution to that individual, the employee / IRA owner. And that IRA owner is now the one who is responsible for completing that transaction, which is now the indirect rollover. This is just a distribution on the left-hand side of the arrow. And on the right-hand side, this is where it becomes the indirect rollover. Now, keep in mind when we're talking about an employer-sponsored retirement plan, those 4 bullets on page 62, we're talking about a qualified retirement plan or QRP under the Internal Revenue Code section 401A. This is where your 401Ks fall, as well as 401Bs, or excuse me, 401As. Also talking about 403Bs, which are generally your universities, your school districts, then your governmental 457B plans, which by title you can tell is government, and then our federal thrift savings plans or TSPs. So when we say employer-sponsored retirement plan, that's kind of a collective for any one of those types of plans listed in those 4 bullets. If money is moved from an employer plan to a traditional or to a simple, you're going from your pre-tax account to a pre-tax traditional or simple IRA. So there's no additional tax liability. If, however, the employee IRA owner is moving money from an employer-sponsored retirement plan, those pre-tax dollars, to a Roth IRA, which is an after-tax account, this is now going to be subject to income taxes, whether it's done directly or indirectly. The owner will have income taxes due. So you'll see that in the paragraph right above your diagram on page 62, that if they go traditional or simple, then they retain that tax deferment. If, however, they move that into a Roth IRA, it is subject to income taxes. It is not subject to the early distribution penalty tax that Jeff talked about earlier, because it is staying in an IRA. but it is subject to income taxes. So only one part of those potential tax liabilities that Jeff spoke of. Excuse me. Now, looking over at the, well, let me point out the note on the bottom of page 62. You'll see it again on 63, and you've seen it before, but I just want to point it out because it applies here as well. Again, when you're moving from a plan to an IRA, directly or indirectly, there's no age requirement, no eligibility requirements as far as eligible compensation, and there's no dollar limitation. So again, anybody can do it as long as they're eligible to move the money out of the plan. Generally, you can't just take money out of your plan. You've got to have some sort of triggering event that allows you to access those assets. But once that happens, there's no age requirements, no eligibility from an earned compensation standpoint, and no dollar limitations. From the plan standpoint, on page 63, we also have potentially, depending on the employer, what's called a designated Roth account. And this would be simply a Roth 401k, a Roth 403b, or a Roth governmental 457b plan. You'll see that in those 3 bullet points on page 63 as well. When money comes out of an employee's paycheck, if the plan is offering this designated Roth account versus the employer-sponsored retirement plans that we talked about on the previous page, when the money comes out of the employee's paycheck, if it's going into a designated Roth account, it would go in after tax. So they're not seeing that as a pre-tax deferment into a plan. It's going to be an after-tax deferment into that designated Roth account, the Roth 401k, Roth 403b, Roth governmental 457b plan. So it's handled just a little bit differently on the plan side. But as far as we're concerned on the financial organization side, if they are eligible to move those assets from their designated Roth account, they can do so directly or indirectly, but you'll notice that they can only go into a Roth IRA. They cannot move designated Roth accounts into a traditional or into a simple IRA. It can only go into a Roth IRA. Again, directly, straight across. We'll talk about those characteristics in just a moment. And then in indirect is when the owner has access. So there's a true distribution from the plan, and the owner then has possession of the money. They then in turn can complete what's called the indirect rollover by bringing those monies into the Roth IRA at our financial organization. Again, with the note at the bottom of the page, keep in mind that with this type of movement, there's no age requirement, no eligible compensation requirement, and no dollar limitation. Again, we are just relocating where those assets that are currently invested are held. So no new money coming in, just redistributing where those assets are being invested or located. Now, from a plan, whether it be an employer plan or a qualified employer plan or a designated Roth account, there's characteristics for the direct rollover and for the indirect rollover. And so that will take us over to page 64. The first chart at the top of page 64 that we're going to look at is our direct rollover. Now, again, keep in mind that we are going, you'll see from the diagram as well on the screen, we are going from an employer plan to an IRA. And if this is from an employer-sponsored retirement plan, non-Roth plan, this can go to their traditional or their simple, and it remains tax deferred. It can go to their Roth, where they are subject to income taxes upon that movement, or it can come from the designated Roth account and go to a Roth IRA. Because it is coming from the plan in a direct fashion, the plan administrator is the one who's responsible for determining eligibility. Generally, they're going to receive a letter from the plan that tells them how much they can move, the methods that they can move it. They have to make an election and send it back to the plan administrator. But the plan will then take care of the movement of the money. The plan is going to make the check payable to the receiving financial organization, which has been directed by the employee. And they will generally do that for benefit of the employee. So it would be for payable to, your financial organization for benefit of our FBO Deborah Shipman. Now, 99.99% of the time, they are going to mail that check to me, to Deborah Shipman, to the employee, the IRA owner. I then in turn will bring it over to the financial organization. There is an opportunity or a chance that they could mail it directly to you. So just kind of be aware that that could be happening. And just because you receive a check payable to the financial organization for benefit of Deborah Shipman doesn't mean that it's from another IRA. It could be from a plan. So if you don't have that information ahead of time from the client, you are going to want to reach out to the client and ask, did these assets come from your plan or did they come from another IRA? Because remember, transfer is IRA to IRA and direct rollover in this case is plan to IRA. So while there's no constructive receipt, majority of the time from what I have experienced personally and what I have found out from financial organizations over the years is that those checks are going to be payable to your financial organization for benefit of the client, but mailed to the client. Because the check is payable to your financial organization, there's no 60-day rule. I don't have access to the money. Even though they may have mailed the check to me, I don't have access. I can't cash the check. Therefore, there's no 60-day rule. Whenever there's money coming from a plan going to an IRA, there's no once per 12-month rule. So I can do this more than once in a 12-month period. There's no rolling 365-day period. That's only for IRA to IRA when the owner has access to it. Because the plan is making this payable to the receiving financial organization for my benefit, there's no mandatory withholding. So if $100,000 is eligible to be moved and that's what I've requested, the check will be for $100,000. There's no mandatory withholding. Now, even though I have no access and there's no time limits and there's no withholding, the IRS says that this does have to irrevocably be designated by the owner as a rollover contribution. And that's because it's called a direct rollover. We're moving between two different types of retirement vehicles, and therefore the IRS wants to know what's happening. So we do have to irrevocably designate that as a rollover, and we also have to have reporting occur. The plan is going to create the 1099-R showing that movement out. They're going to report it accordingly, showing that the owner had no access to the money. And the receiving financial organization, which is yourself, excuse me, will create a 5498 showing the receipt of those assets. Because there was no withholding, those dollar values should match. I will still, as the owner, have to report that when I file my return. But there will be no tax liability, assuming, again, I'm going from a plan to a traditional or a simple. Again, I could potentially have tax liability in the event that I move it to a Roth IRA. And I also have to report this if it is from a designated Roth account going to a Roth IRA. So in all of those instances, the plan is going to create a 1099-R for the distribution. And I use the term distribution loosely for the money coming out, because nothing was actually distributed to the owner. And then the 5498 will be created by the financial organization showing the money coming back in. Now, with an indirect rollover, those characteristics are going to be a little bit different. The first one, however, is still the same. We are still moving between a retirement plan and an IRA. So the distributor is still a plan, the receiver is still the financial organization's IRA type. In this case, the plan is going to then distribute the money to me, which now says that I'm responsible for making sure that I don't roll over any more than what I was eligible to. So that now falls on my shoulders because I'm now going to have constructive receipt of the assets. The plan is going to make the check payable to Deborah Shipman, and they're going to mail it to me, at which point I have all of the ability to cash the check and decide what happens to all of those assets that are there. Because I now have constructive receipt of the assets, whether I choose to cash that check or not, the IRS says that you now have 60 days from the day that you receive it to complete that indirect rollover. Again, the plan has done the distribution today. They put it in the mail tomorrow. I don't receive it till Monday next week. Then that's when I received it. So it's 60 days from when I've received the assets, and then Tuesday is day number 1. Because the day after is always day number 1 on the 60-day rule. So it's 60 days from the day that the owner received the assets. Even though I had access to the money and their 60-day rule is in play, Because the money is coming from a plan going to an IRA, there's no 1 per 12-month rule. So again, this can be done more than once in a 365-day period. Only do we have the 1 per 12-month rule in play if we're going from IRA to IRA with owner access. Because I will have access to the money, the check is payable to me, and the plan has no idea that that is for sure going to be rolled over as I've indicated. They are responsible on this distribution to mandatorily withhold 20%. Now, federal withholding on an IRA distribution, mandatory without an election, is 10%. Remember, they can choose, like Jeff said, anything between 0 and 100% now, but if they don't make an election, it's 10%. Well, on a plan side, there is no choice. In this scenario, they will mandatorily withhold 20%. So if that is $100,000 in my plan that I want moved, but I want to have the check payable to me, they are actually only going to send me, excuse me, 80% value. In this case, $100,000, 20% is going to be $20,000. So I'm only going to receive a check for $80,000. Now, the withdrawal is going to be for $100,000. 20% gets sent off to the IRS, and 80% is in a check payable to me. So I've only received $80,000. I have, however, 60 days to roll over the full distribution amount, the full $100,000, but I only have $80,000 in hand. So I can, within that 60 days, find or make up any portion of that missing 20%. So let's say I go ahead and take $15,000 out of my checking account. I don't have that much in there, and put it into the IRA as a rollover. Now I've rolled over the $80,000 that I have plus $15,000, and now I'm only short $5,000. Anything that I'm short on, the distribution again is $100,000, and I've rolled over $95,000. Anything that I'm short on is subject to income taxes and a penalty of 10% if I'm under 59.5. So that is going to be my responsibility as the IRA owner. If I don't make up any portion of that missing amount, then I'm subject to withholding, I'm subject to income taxes on that full distribution shortage. So remember, the withdrawal is $100,000. I only roll over $80,000 that I have in possession. I don't make up anything out of pocket. The missing amount is $20,000. I'm now subject to income taxes on $20,000. Excuse me. And if I'm under 59.5, then I'm going to be also be subject to that early distribution penalty tax as well. When I bring that money in, assuming I do, any portion up to 100%, again, maybe it's only the 80% I received, or maybe it's part of the missing 20%, or maybe it's all of it, but I do have to irrevocably designate that amount as a rollover. And that again can be done on our forms. You want to check your forms providers forms to make sure that that is included, because again, on a direct or indirect rollover, I do have to irrevocably designate that as such. As I mentioned, this is a distribution to the client, and then once they complete that transaction, it becomes a rollover on what they bring in, and that does create reporting. That creates the 1099-R from the plan, and it will create the 5498 from the financial organization showing the amount that was rolled over. If they match, if they make up the whole missing 20% out of pocket, then there is no additional tax liability if it was moved from an employer-sponsored retirement plan to a traditional or a simple. It is still subject to income taxes if it's moved to a Roth. And again, same rules apply on the designated Roth account movement to the Roth IRA. Everything is still reported, both the distribution and the subsequent rollover contribution. The owner also has a responsibility to report that on their taxes. Any questions on that before we look at moving it the other direction from an IRA to an employer-sponsored retirement plan? Okay, I'm not seeing anything. I'm not hearing anything. So we are going to go ahead and take a look at page 65. In this case, we're moving, as I said, opposite. We're moving from an IRA to an employer-sponsored retirement plan. So you'll see again, direct rollover or indirect rollover. That's the language whenever the plan is involved. But you'll notice that we only can move from a traditional IRA or a simple IRA. Remember that simple IRA has to have met the 2-year clock before it can move to a non-simple IRA. But we cannot move money from a Roth IRA to an employer plan or to a designated Roth account. So only from a traditional or simple to an employer-sponsored retirement plan, directly or indirectly. And again, we'll talk about those characteristics in just a moment. Before we do, the note on the bottom of the page, as a reminder, there's no age requirement, no eligible compensation requirement, and no dollar limit either. So if you are moving money as an employee or an IRA owner in this case to your employer-sponsored retirement plan, it has to come from a traditional or from a simple after the 2-year rule has been met. I would recommend that they talk to the plan to make sure that they accept IRA assets. Not all plans do because they have to keep track of them separately from employee deferrals and plan rollovers. So they do want it to probably talk to the plan to make sure that they'll accept that. If, however, they do, only pre-tax assets can be moved. So it's the employee's responsibility, the IRA owner's responsibility to ensure that they're only moving pre-tax assets. Nothing that would be considered basis. Jeff talked about basis. That would be the after-tax dollars. Because this is a direct rollover, the IRA financial organization will make the check payable to the plan for benefit of Deborah Shipman. Excuse me. And likely they'll mail it directly over to the plan, but they can give the check to the employee to deliver to the plan as well. Because again, there's no constructive receipt, so I can't cash the check. It's not payable to me. It is payable to the employer for benefit of me. Because I don't have access to the money, there is no 60-day rule attached to this type of transaction. And we are going between 2 different types of retirement vehicles. Therefore, there's no 1 per 12-month rule in play. Also, because the check is payable to the receiving employer in a direct rollover, there is no mandatory withholding from the plan. So it is extremely clean from that perspective. And there is reporting that has to be done, but ultimately it's pretty clean from the perspective of no time limits, no withholding, excuse me. So as I mentioned, it is a reportable transaction. You will, as a financial organization, create the 1099-R showing the direct movement out. And then the owner will have to report that on their tax return as well. If we are talking about an indirect rollover, we are still moving from the IRA traditional or simple. And again, the simple has to have met that 2-year rule. That's the owner's responsibility to determine. And over to the plan. Again, still only pre-tax dollars, and that is the employee's responsibility, the owner's responsibility to make sure that they don't have any after-tax dollars or basis moved. But this time you are going to make the check payable to Deborah Shipman. You're going to put the money in my checking or my savings account, or you're going to be giving me cash, whatever I request, but I have constructive receipt of the assets. Because of that, I have a time limit. I can only have 60 days from the day I receive those assets. Day 1 is always the day after, to put that into my plan. So I do want to make sure that I meet that 60-day rule. Because we're moving between 2 different retirement vehicles, again, there is no 1 per 12-month rule in play. Even though my intent might be to move it over to the plan, this is just a distribution from the IRA, and therefore the financial organization does have to offer me withholding. I can certainly waive if my intent is to move the whole thing, but I do have to make a choice. As Jeff said, I can choose anything between 0 and 100% now, 0 again being waive. If, however, I don't make an election, you mandatorily have to withhold 10%. The financial organization will again create the 1099-R. Not only are we going between the IRA and the plan, but there was a true distribution. And so it is something that the financial organization is going to create a 1099-R4, and I will also report on my tax return. So let's take a look, unless there's any questions that come in, at pages 67 and 68 for our activities. We're going to take a look at Regina Howard, and she's on page 67. She is 38, and she would like to move her traditional IRA assets from Someday Financial to her traditional IRA over at your financial organization. What are the two options? Using chat, you can abbreviate with letters if you like. What are Regina's two options for moving her IRA assets to the IRA at your financial organization? Transfer, rollover, direct rollover, indirect rollover. And again, there's two. IRA to IRA, what are the two options that she has for moving money? Thank you. One is transfer and one is rollover. So those are the two ways in which she can move IRA to IRA assets. Now, if she has a check in number 2 payable to herself for $15,000 and she only rolls over $10,000, what are the tax consequences of the transaction? Using chat, how much is she going to be subject to income taxes on? What do you think? I'll flip it up and then I'll throw up my answer for you. So the missing amount, short answer, 5,000 in this example. Thank you. Oops, I forgot the second part of the question, but we'll talk about it. So she's going to be subject to income taxes on the missing portion. In this case, $5,000. Now, because she is also under 59.5, she's 38, if I recall correctly, then she's also subject to the 10% penalty on the taxable portion of the missing amount. So if the full 5,000 is taxable, then it's 10% of 5,000. What are the tax consequences if the entire $15,000 is payable to your financial organization for benefit of Regina Howard? What are her tax consequences if she does a transfer in this case? Check payable to your financial for benefit of Regina Howard. Absolutely none. Thank you. So there's no tax consequences. It's a very clean transaction for her and for you because there'll be absolutely no reporting as well. Now, if we look at page 68, we're going to take a look at Javier. Javier is 68 on page 68, and he is moving $200,000 from his 401k plan with his former employer to his traditional IRA with your financial. What are the two options that he has to move plan assets to your IRA at the financial organization? Okay, so I'm not seeing any takers, so it's direct rollover and indirect rollover. In question 5, now if he requests a distribution, so it's going to be money that he wants to receive, a true distribution, and he wants to have $200,000 distributed to him, how much is he actually going to receive? So it's not payable to your financial organization, but payable to him. And he wants $200,000 distributed. How much is he going to receive? Thank you. In this case, it's going to be $160,000. So remember, there's 20% mandatorily withheld in that scenario. So the withdrawal is going to be for $200,000, but they are going to withhold 20% of that. 10%, if you're bad at math like me, 10% is 20,000. So doubling that would get you 40,000 for your 20%. Subtracting that out from the 200,000 gets you the $160,000 that he's going to physically receive via check, probably not cash, most likely a check, but that's what he's going to get. Now, what are the tax consequences if Javier only rolls over the $160,000 that he received to his IRA? What is he subject to income taxes on potentially? The missing 20%, or in this case, $40,000. Now, Javier is 68, so there won't be an additional 10% penalty applied That has nothing to do with the fact that it's plan assets where it came from. It has to do with the fact that Javier is 68. If Javier was 38, like Regina on our previous example, then Javier would also be subject to the 10% early distribution penalty tax on the taxable portion of the missing amount. However, since he is 68, he only has to worry about potential income taxes and not the early distribution penalty tax. If he instead wanted the check payable to the financial organization for his benefit, what would be the amount that the check would be written for? Remember the distribution amount that he wanted to have out, but he this time wants it paid, thank you, to the financial organization. In that case, there's no withholding, so it will be for the full amount that he requested, which is the $200,000. Now, all of page 68 is going to be reported, regardless of whether he had access or no access. And that's both from the distributing side, from the plan side, as well as the receiving financial organization side. So on page 69, I have a sample again of our contribution investment selection form. You saw this earlier in the funding section, but we looked at it a little differently. We only looked at the contribution piece. So here you have, again, the contribution amount. In Javier's case, this would be, let's say, $160,000 because he's doing the rollover versus the indirect rollover versus the direct rollover. And the contribution date would be today. And in either case, whether this was the 160 or whether it was the 200,000 check payable to your financial, we would still be marking the rollover box. Anything coming from a plan is a rollover. If this was from an IRA and he had access to it, it would also be marking the rollover box. Remember that any of those three transactions, IRA rollover, direct rollover, or indirect rollover, both from the plan, he would have to irrevocably designate this as a rollover. So the language that we have here on our forms, again, check with your forms provider. This says by selecting the transaction, I irrevocably designate this contribution as a rollover. So in this particular case, that's where we have our language. And then the Javier in this example would then sign the bottom of the form. That is his irrevocable designation. If this was a transfer for Regina, the full 15,000 would be 15 up here on the contribution amount with today's date. And because it's from an IRA payable to our financial, we would mark the transfer box. Now, as far as reporting, you have seen this form on page 70 earlier, and this is just going to be completed a little bit differently. Again, traditional and Roth each have their own 5498, but they are going to be utilized in the same fashion. For a rollover, we would use box number 2, whether it was an IRA rollover, an indirect rollover from the plan, or a direct rollover from the plan. So if I did all three for $1,000 this year, this would be a total of $3,000 in box number 2. Box number 5 would be the value of the receiving IRA at the end of the previous year. So in this case, 12/31 of 2022. And then in box number 7, we're going to mark the IRA box if it went into a traditional. And if it went into a Roth, instead, we would mark the Roth IRA box in box 7. The last thing I have for you, and I'm going to take care of popping these up for you on page 72, is our 4 methods of movement for portability. We have our transfer, our rollover, whoa, again, one too many clicks, direct rollover, and indirect rollover. So those are the 4 methods of movement for IRA and or plan assets, depending on which direction we are going and where the money is coming from. Any questions at all for myself or for Jeff on anything that we covered or didn't cover today that you would like to unmute your phone and ask or send through chat? Jeff's back on with us as well.
Any questions on anything we didn't cover today? We'll give you that too.
Okay, while we're waiting for that, just to bring this up, Jeff had brought up the guidebook before and showed you the job aid section. So there is, just after this page, you would start with job aids, and you're going to see charts that you saw in the book, but you're also going to see a lot more information that you probably didn't see in the book. And it will have a page number reference if it was in the book, for example, as to what page number it references back to. But all of that is going to be in the back of the guidebook for you if you need any of that back there. But again, additional information for you as well. Thank you so much. I'm not hearing anything, seeing anything. So whenever you'd like to go ahead and log off, unless Stephanie, are you on? Did you want to come back on and say anything at all? And I believe that you do have a pop-up from Zoom is from Michigan Bankers. So if you can complete that, please feel free to do that. And I think that's it. Otherwise, for those of you who are joining us tomorrow, we'll have the same start time for advanced IRAs. It'll be Jeff and myself again. And thank you for attending today. We look forward to working with you guys who are coming back tomorrow.
Thanks, everyone. Have a great evening, and some of you hopefully will see you tomorrow.